allowance and state employees call for a strike. This is not support for.
Actually, the letter was circulated by the High Court Employees Association. In that letter, they have not mentioned about the DA issue as a primary issue. They are mentioning about some statement made by
Lordship, I am not
parties.
entered into the DA. Just I have objection only for.
No, that we have dealt with in the
Kindly let it be
administrative side so far as the High Court is concerned.
I have served upon all the responses, Lordship, according
Tomorrow, first case.
Lordship.
But I'm paying for leave to file appeal.
To inform the government pleader, and
I will inform all.
Madam, may I pay to file appeal, my lord, without certificate copy, my lord?
Date of
Pay
the
for
order.
leave, my lord.
Date of the order.
Date of the order 23rd March, my lord.
23rd. Yes.
Yes, my lord, kind leave to mention, my lord, the contempt application which I had mentioned yesterday, my lord, with the leave of this honorable court, we have filed it, my lord. Now we are making an application, my lord, before my lord's secretary, my lord, for assigning a bench, my lord.
Yes.
Because it needs utmost urgency, my lord.
Definitely.
Lord,
I'm grateful, my lord.
my prayer also to file the appeal matter without certified copy.
Date of the order.
Date of 2nd February, my lord. File is not available, my lord. I have duly applied.
2nd February means it's out of time.
It is true, my lord, but file is not available. That's why I
What happened to your certified copy?
certified copy, my lord. File was not sent down, my lord. That is in the department, my lord.
You give the number, we'll verify. No, the writ petition number, not the file. You write down a slip, we'll find out what happened to the why it is not verified. Yes.
My lord, regarding Ramnavami issue, my lord, I have
Pardon?
regarding item number 1 on the violence on Ramnavami procession, my lord, I have filed a similar application. My application be tagged with.
No, you will hear
My
this.
lord, yes, my lord.
No. You wait. Matter is yet to be called.
My lord, matter is supposed to come
No,
up tomorrow.
the multiplicity is not required, sir. We will hear you. There are a lot of advocates who will be heard in the matter.
On that day, we mentioned the matter praying for your lordship, my lord.
We cannot permit 100 writ petitions on the same cause of action. Already one writ petition is there. We have passed certain orders. Yesterday, supplementary affidavit has been filed. You wait for your turn. We will hear you. We will not entertain a fresh writ petition.
Item number 761. This matter is pending before your lordship.
Monday, you please mention, sir, for upgradation, inclusion.
Lord, contempt application of the order passed by the Honorable the Chief Justice Prakash Srivastav and Justice Bharadwaj.
Give a letter to the secretary.
Yes, Lord, I will give a letter. It has to be assigned, Lord.
Yes. Every day it will be placed.
It has to be before a bench of where Justice Bharadwaj is the
Yes.
party.
May I have lordship's kind leave, my lord, to mention, my lord, to upgrade one matter, my lord.
Monday. Already we have collected 50 letters.
Much obviously.
Oh, what to do?
Appellate side, daily list, serial number 1.
Appear for the repetition.
I appear for the immunity.
That report is ready. Sir? Report is ready. AG.
Yes, my lord, I have, my lord, the reports.
And yesterday they have filed a supplementary affidavit.
Yes.
There are 2 supplementary affidavits. The one which we relied upon on the last occasion without getting it affirmed. We have affirmed the same, got the pagination corrected, and we have already served upon the.
Very good. Which is the first supplementary?
The first one is the thicker one.
Thicker one is
the first one.
So we will call it supplementary affidavit 1.
SA1.
Supplementary affidavit 2.
SA2.
But the supplementary affidavit 1 refers to the incident of 30th of March and 30th of January, 30th of March and 31st of March. And when the supplementary affidavit 2 refers to the Rishira incident on 3rd of April 2023. I need to show to your lordship not the two incidents which had strike.
No, I
Part
think
of-
there is no dispute on that. All social media, newspapers have extensively covered. There have been press statements given by important people on the issue. Is how best AG has to tell how best you have planned to tackle the situation. Because from the media we learned that Hanuman Jayanti procession is to take place, and you have made some new form, etc., which the people who are organizing the procession have to fill up. But this is what is required is prevention is better than cure.
Lordship's absolutely right.
So I had occasion to deal with, I said the last time, this Ganesh Chaturthi procession. That is, the idol is taken to the Bay of Bengal for immersion. So a detailed SOP has been drawn. To my knowledge, sitting single, I have dealt with the same matter year after year, as well as in the division bench. To my knowledge, for the past 8 to 9 years, there has been no untoward incident, especially with the route goes through very sensitive areas, like what has been mentioned here. But if suppose the police force is inadequate, you are not able to deploy, then you take the assistance of some other force like a paramilitary force or something to assist the state police. After all we have to ensure is the citizens' safety to be protected. In fact, yesterday, there's a letter written by one of the judges who's in, RG has given that letter. He's an additional district and sessions judge in Diamond Harbor. He says that I want to inform, that is, he has written to the Registrar General. I want to inform you that the communal violence is going on in Rishra, and I reside with my family at so-and-so place, Serampur. But at present, I am posted in Diamond Harbor as additional district and session judge. For the sake of my service, I reside at Diamond Harbor in the judicial quarters. Yesterday, I was present in my house situated at Rishra, and communal violence started there. And thereafter, I've requested the police station for getting help, but did not get any help from them. Even I tried to talk with the Deputy Commissioner of Police, IPS, with that mobile number so-and-so, but he paid no heed to my request and did not provide any kind of help. Antisocial elements are roaming on the street with armed with swords, dagger, petrol bomb, and other dangerous weapons in my locality. And they plan to burn the house of the members of so-and-so. There is also Hanumanji temple near my house. So they are also targeting the said temple, and there is every chance of spread of communal violence at the instance of antisocial persons. The law and order situation is out of control. I am now living at Diamond Harbor, very much worried about the safety and security of my family members, consisting of my wife, 2 sons, and a daughter. I am not getting any help from the local administration. I humbly pray Your Honor to look into the matter and pass necessary order directing the local administration to provide police help or deploy armed police near my house to protect life of my family members. Now, what happens is, sir, all these judges are residing in that particular district. They have to go for work. And your reports are, you have said that so many arrests have been made. Obviously, those people will be produced before the court for remand or whatever it is. Then the surcharged atmosphere will also get into the court complex. So something needs to be done on this. At least these routes can be barricaded. And in fact, what they used to plan there is, they used to have a peace march with mounted police, at least 5 to 6 days before the date on which the immersion takes place. So every day, morning and evening, just to reassure the public that we are here to take care of everything, nothing untoward will happen. Something needs to, sort of solace, or they should feel that they are secure. That's it. You are making all arrangements. See, these people who are filling up the forms, do they give a declaration that if anything goes wrong with any of their members, at least one person should be responsible for that. He can't come and say somebody entered it, etc., etc. Something needs to be done on this.
My lord, the persons applying for permission,
Hmm.
my lord, they have to be, my lord, with, my lord, in the procession right through.
Yes.
And my lord, they should take the response. They'll be the person responsible.
But does that form
My lord,
contain
the
any-
new one which has come out, my lord, the Kolkata police, the 27 conditions, my lord.
Hmm.
My lord, I don't think, my lord, that,
Yeah,
my lord.
yeah, a jurate portion or a declaration can
Correct,
be there.
correct.
That secretary of that committee or that club,
Yes.
whichever is conducting the procession, I declare that I abide by all the other conditions and I take personal responsibility for any of the violations which are committed, something like that. And in fact, the routes also can be so designated, made as short as possible, so that the religious sentiments are also protected. At the same time, the common man also is not inconvenienced. That's the best you can do. And you can think aloud also. If suppose you need a further, suppose there is a natural disaster, or like we had this Amphan cyclone. So a national team will always come to assist the state team. So there is, if you feel that your deployment of the state police, because you can't shift the entire state police to that district,
Correct.
What will happen to the other districts? So if there is going to be some shortage of hands, you can think aloud and take a decision.
Just to point out before your lordships, not two documents, not the steps taken by the state authorities, not which have been proved to be inadequate. If your lordships kindly have a look at page 24 of the first supplementary affidavit and page 13 of the second supplementary affidavit.
Page 24. Yes.
This was dated 31st of March 2023, the day after the occurrence of the incident at Howrah. Whereas reports and request has been received from the Additional Director General and Inspector General of Police Law and Order West Bengal with a memo number so and so dated 31st of March 2023, that in view of the recent events in some areas, internet transmission and voice over internet telephony may be used for spreading rumors for unlawful activities in some areas within the jurisdiction of Howrah Town, Asansol Durgapur Police Commissionerate and Barakpur Police Commissionerate. So there is always an apprehension of this being spread out.
From this district to the other
districts. And please have a look at page 13 of the second supplementary affidavit. This is Commissioner of Police not imposing 144 on 4th of April 2023. Information indicates that as an aftermath of incident happened near Wellington, Jute Mill and Shondha Bazar area, there is a possibility of mobilization of riotous mob at Rishra PS and Sirampur PS under Chandannagar Police Commissionerate on 4th of April 2023. And whereas it appears that the mobilization in every likelihood may cause serious breach of peace in areas under Rishra PS and Sirampur PS of Chandannagar Police Commissionerate. Whereas it is apprehended that agitators may carry the prohibited weapons, articles which are hazardous and that may become violent by trying to again forceful entry into the government establishments, offices by violating the law, which may result into affray and serious breach of peace by damaging government properties. And whereas I am satisfied that there is every reason to believe that agitators and disgruntled persons may attempt to create disorder and trouble in the area coming under the Rishra and Sirampur areas and may cause breach of peace, public tranquility, etc., there is sufficient ground for proceeding for which immediate prevention is required. Therefore, I so and so, in exercise of the power conferred upon me under section 144 of the CRPC, do hereby prohibit the following inside the area of Rishra and Sirampur PS with effect from 800 hours of 4th April 2023 till the normalcy return of the situation. Now, this is for Rishra.
No, these are all reasons to record a satisfaction that 144 needs to be, because Supreme
He
Court
apprehends.
No, that's it. See, after that Supreme Court decision, what is that? Mr. Anna Hazare.
Yes.
Yes, correct.
After that, the Honorable Supreme Court said that satisfaction should be manifest
Reflected.
on the face of the order.
And my lord, that's repeated in Anuradha Bhasin as well.
So that is it. Now, sir, orders are in place. The only issue is how to enforce these orders. how to ensure that these orders are scrupulously adhered to. That's the only, we require nothing else. So it's, of course, it's a state responsibility to ensure there's no breach of peace. But how to go about? So actually, this litigation should not be construed as what do you say, adversarial or
Correct, my lord. I'm
giving a political color, or though the writ petitioner may be
clear, my lord. My lord, I could have, but I didn't take the point. And my lord, I must tell your lordships.
In fact, if that is going, if the court feels so, we can always discharge the petitioner and make Mr.
Yes.
Soumya Mazumdar
Yes, my lord.
as amicus curiae and go ahead with
Yes.
the matter.
My lord, I must tell your lordships, my lord, and my lord, in all fairness, my lord, to the writ petitioner here, my lord, in a matter, my lord, where he, my lord, the writ petitioner wanted to go, my lord, to, my lord, these affected areas, my lord, on a letter being written by the commissioner, my lord, to him, my lord, he, my lord, withdrew the writ petition. In all fairness, my lord, I said, kindly make that request. Because, my lord, as political leaders, my lord, their duty is more than the normal citizen.
Yes.
My lord, to ensure, my lord, that there is. And, my lord, I must say, my lord, that, my lord, he acceded to that request and immediately withdrew the writ petition, saying
Today
140.
in the newspaper, there is some other person also says he is not going.
Yes, my lord. My lord, persons who I know, my lord, they have also said, my lord, till 140, which is, my lord, a responsible, my lord, statement. So, my lord, I'm grateful, my lord, that these statements are coming also from political leaders, my lord, which is important. And, my lord, across, my lord, the political spectrum. So that is good, my lord. But in the meantime, also there is, my lord, a bit of rabble rousing. But, my lord, the police has to take care of it. My lord, your lordship suggested, my lord, what we can do, my lord, with regard to, my lord, ensuring, my lord, that the chances of a flare-up, my lord, is completely, my lord, rooted out, my lord. My lord, will your lordships, my lord, give me just, I'll address today itself. My lord, may I just make a few phone calls, my lord, and, my lord, get back to your lordships, my lord.
You can pass over
My
the
lord,
matter.
yes.
No problem.
My lord, if your lordships permit that.
Yesterday, my lord, for the Shibpur area, there has been reimposition of 144, my lord, once again till 7th April.
It is better that way, so that the police will be able to control. Actually, in this procession, no vehicles are permitted.
No, my lord.
People
not
have to
permitted.
walk.
Yes, my lord.
No
In fact, my
cycles.
lord, motorcycles were also, my lord, prohibited. But we found, my lord, that motorcycles were also, my lord. My lord.
No, if the barricading can be done in such a way, like only pedestrians, like people
Yes.
can walk through
Yes.
with the barricading, obviously the vehicles can't enter.
Yeah.
And the designated route can be chosen in such a way that it can't give room for any,
Designated.
it can't give any room for any chance of some disruption. Because what happens is, normally in this Ganesh Chaturthi also, writ petition is filed by a political party. And they will say that they are the major organizers and they will give a plan or a route map. And that the Commissioner of Police and the Director General of Police will examine and they will say, no, this cannot be done. We'll agree for this particular route. And what happens is in that route, as you find in this red road, etc., the barricading on both sides, the entire route will be barricaded. All shops will be closed for probably 6 hours. And the procession will reach the Marina Beach. And there the police will have cranes, lift the idol and do the immersion. So up to that stage, the organizers can come. Thereafter, it's the responsible of the police as well as the Coast Guard. Everybody will be there. And if it's a very big idol, they will take it in a mechanized boat and take it in middle of the sea and do the immersion. So cranes are all stationed. So that's how it happens. So I think that designated route needs to be very, very carefully. See, if suppose all of them have to congregate in one particular place, they can't be coming haphazard here and there. So if at all the procession has to take place, they need to assemble in a particular area and then take the procession, whatever celebration they want, and be done.
Well, they can't come in through by lanes, join halfway.
Yes, that's it.
So the starting point and the end point has to be common for all processions.
Yes. And that's the best method of doing it. Otherwise, it's difficult because the crowd will be in the sort of a frenzy. You can't control, you can't. So the moment they start, some chanting will go on, etc., etc. The mood will get elevated. If some people will be in the elevated mood also, we don't know, and all those things will happen. We will pass over the matter.
Yes, my lord.
And AG can give a note also, one-page note or something like that.
Yes, my
Lord, may I make one submission? Lord, on the repeated incidents in the recent past, including the order which has been annexed to the public interest litigation at page 31, and the subsequent attack on the Honorable Home Minister of Government of India on 25th February. My Lord, there is serious apprehension in the Home Ministry of Government of India. My Lord, since the Honorable Home Minister was not protected, and the view taken by the earlier division bench is that the police authorities of West Bengal have concluded the inquiry by the report without investigating the matter in detail, and it was referred to CBI. Now, this I find in today's newspaper, some statements by the political leader, including the Chief Minister, in the Statesman, that may aggravate the situation, where the responsibility has been shifted to the principal opposition party, which has fallen from my lords, that my lords are aware on the interpretation of Article 257 and 355, read with 7th schedule, list 1, NT2, capital A. The paramilitary forces can be deployed anytime, if your lordship so think, at any place, even without the consent. That is the law made by the parliament in the case of RPS.
Yes, that can be done at the request of the state government also. That can be done. It all.
And that, your lordships also can do this.
Yes, we can.
Now that may, my lord, increase the confidence of the people if there is a road march. And tomorrow there will not be a court. Friday is a holiday. Sunday, Saturday, Sunday, and Monday. If something happens in between, Lord, that will be a serious concern.
We'll do one thing. We'll pass over the matter. Let Advocate General discuss with the concerned persons and come back. Then we will do it. Pass it.
And copy of the report which is prepared, I am told, maybe you will not give it to us.
Lordship, I want to make one submission in this matter.
Yes.
So far,
but there was another public interest litigation.
item number.
Was for an incident in Howrah. But the matter was heard extensively. There was a mandate given by your honorable division bench taking up the matter that the state, if it feels that the situation cannot be contained, immediately petition for the settlement. Once the matter is taken up, I will take print out of that order also.
You please, sir. Yes.
Lordship, in item number 55 is my item, Lordship. On the last occasion, it was directed to be tagged. Lordship, 2-3 things. Your Lordship, it has fallen from your Lordship that state will try to find out the route for the procession, how it would be taken. Now, the problem is the mode of attack, which we have seen in Howrah incident, that throwing the stone from the rooftop of the building. So there were the allegations, the report also may be found that from the rooftop of the building, the stones were thrown on the procession itself. So there is an element that it could be pre-planned, the entire thing, because when the procession is religious in nature completely, that might not create any trouble. But when the procession is political and religious in nature, mixed, then it is creating the trouble and communalism is created. Now, Lordship, in my writ petition, I have referred to one comment, but by one of the very responsible person of the state. I don't want to make the name, but she has been made a party to this petition, that when she is making a comment that this particular community, if they are attacked by another particular community, which is again compared with a political party, and this has been instigated. Now, persons from that political stature, holding the constitutional office, should not be allowed to make such a comment which is politically enough to instigate this kind of problems. Lordship, there has to be at least one judicial request for all political parties, including the holders of the constitutional office. Because today the problem itself here shows that the state is not, the secular character of the state is not safe in the hand of the present government in the state. So I made her a party in this. The stricture should be given to those persons.
Yours is item 55.
Item 55, Lordship.
Keep that file also along with this file. Anybody else wants to make a submission? Somebody mentioned he has filed a writ petition, he is gone off. All right, pass over.
On the National Investigation Agency Act, subsection 5, with the non-obstante clause. Submission period as advance of
What time we can call the matter?
My lord,
By 12 or so?
12 o'clock, my lord, if your lordships, my lord.
1 hour you've got.
Yes, my lord,
Serial number 2.
My matter, may I be?
Here, 4.
My lord.
অন্য মামলা
বারোটায় তো নেবে, ওগুলো 12টায় নেবে।
Which Rashid? Do not. Implement.
Yes.
Yes, madam. It's my appeal, my lord. I appeal for, my lord, the Hindustan Petroleum Corporation Limited.
I beg to appear for the writ petitioner respondent. I am for the respondent number 3 and 4, Regional Transport Authority, Patna.
Before taking your lordship to the documents, may I, in a nutshell, may I give your lordships?
So there is an interim order.
There's an interim order in this appeal.
And the appeal has to be heard.
The appeal has to be heard.
How long all of you are likely to take?
My lord, shouldn't be more than, my lord, half an hour, my lord.
The same for me.
For my submissions.
Then we'll fix a date for the now.
Malad, the thing is that Malad, it's a 5-year contract, Malad. Which
This
started
is for the tanker trucks.
Yes, tank trucks.
Tank trucks. It started in 2018 and it is to expire in 2023, Malad. So Malad, that the Honorable Single Judge also takes notice of the fact that 4 years have gone by in the pendency of the litigation, Malad. Malad, if at all, Malad, a date is fixed, Malad, if it may be a shorter date, Malad.
How short is the question?
It was fixed today for taking up for final
So it
disposal.
says at request of the learned counsel for the appellant, appeal is adjourned. List on 5th April. Interim order to continue. And what was the relief you sought for in the writ petition?
Malad, in the writ petition, Malad, I had sought for Malad an interpretation of a clause in the tender, which had given me a right to be treated preferentially. It is not a case where I have not been allowed in the tender. It is a case where I have not been preferentially allowed in the tender because according to them, we are not state registered, meaning not registered in the same state because this tender is of Bihar.
Yeah.
They wanted us to be registered in Bihar. Our vehicle numbers stated NL, meaning Nagaland. They said that if the number is NL, you are not state registered. Our case was that the DTO Patna had certified that we are registered in Bihar, and the DTO being the authority under the Motor Vehicles Act, but the oil company cannot step into the shoes of the registering authority or the transport authority of Bihar and say that you are not state registered. But that was the point.
No. So what does the state registered?
But their tender term says that state registered TTs, meaning tank trucks, will be given preferential treatment. Because this tender.
But your registration number of the vehicle is Nagaland.
Nagaland. Initial registration is in Nagaland. But we have applied for the registration in Bihar and before the date of the final date of tender, and we have participated. The Bihar government, the Bihar Transport Department says that yes, you are registered in Bihar. But they say that since your number is NL, you will not be treated as.
Now, one issue, sir. Now, I have brought my vehicle from Chennai.
12 months is allowed, Malad.
It's a Tamil Nadu registration vehicle. I am flying the vehicle here. But after the amendment to the Motor Vehicles Act and the rules, now this re-registration concept is gone. Otherwise, within 3 months, I have to re-register it in West Bengal. Now, if suppose now because of the what is it called as one-time tax. Earlier, we have to either pay annual tax or quarterly
lifetime
tax.
tax.
Lifetime tax. Lifetime tax. So therefore, the tax is already collected. So the re-registration concept is gone, and this Vahan app is there. You can track the vehicle wherever it is.
Wherever in India.
Even it goes under the sea, they can track it. So this loses that your condition needs to be interpreted in terms of the Motor Vehicles Act.
Yes. But that is exactly my submission. And that when at the time when this was considered, the tender.
When he applied.
Yes. That's in 2018. But then this amended rules had not come into force. So it was as per the previous rules. Now there's a concept also of Bharat registration. So that for those who has to go from one state to another, need not keep on applying for change in the registration. So that the new Bharat registration number BH number is being granted. So that is to obviate the difficulties which a vehicle owner may face for having to apply for.
According to you, in 2018, when you invited the tender, the vehicle had to be registered in the state.
No. My clause in the tender is that state registered tank trucks would be given preference. It's only a preference. It's not that for other state registered tank trucks, they shall not be entitled. So the tender condition was split into two clauses. First part is two halves. First part is state registered would be given preference. Now, so far as the non-state registered tank trucks from different states are concerned, if they are plying in existing contracts with the oil manufacturing companies, meaning oil marketing companies, meaning Indian Oil, Bharat Petroleum or Hindustan Petroleum, then if they have applied for registration in a new state from the erstwhile state, along with the copy of that application and the NOC from the transferor state, their applications can be considered. But there's a rider to it that it can only be considered if it is lying in an existing contract. So if it is a case of a new tank truck, meaning thereby that they do not have any existing contract with any of the oil marketing companies, then my lord, the preference would be state registered.
So preference would mean if two people are equivalent.
Yes.
And he has to be preferred.
He has to be preferred if it's a Bihar registered. If it is not, then
if the transport authority say, let us assume on the date of tender, much prior to that, he has applied to the Bihar state.
Yes.
Please transfer my registration. The registering authority takes his own time.
Yes.
But all that he can do is mention to you that Sir, I have already made my application before the Bihar State Transport Department, and they are yet to do the registration. But please consider my application under the preferential clause. Probably later on, when you process the tender,
In the interregnum, it happens. Yes.
he says
It has so happened. It has so happened. And
But in
the
that
new
event,
smart card which has been issued under the government of, it's written government of Bihar. Malad, the smart card says issued by the Department of Transport
Bihar.
in Bihar,
in
but the
Bihar.
number remains to be NL. Now, Malad, that number,
now, on what date you applied for registration in Bihar?
Malad, much prior to submission of the tender.
Tender.
And Malad, only one thing I know.
On what date the Bihar RTO?
Malad, this perhaps Malad came somewhere around August.
And by then the tender was opened.
By that time, tender was opened and the LOA was issued in October.
This registration should date back to his date of application.
Malad, there's another.
It dates back to date of application.
But there's another very important fact to be here, Malad, mentioned here, Malad. There was two petitioners in a different writ petition, absolutely similarly circumstanced. Malad, the honorable single judge in that matter, Malad, had already allowed the petition while this remained pending. That order was placed before the honorable single judge in this matter. Honorable single judge takes note of the fact that in that matter, the other concurrent bench has allowed the similar writ petition and the oil company did not prefer an appeal from that order. Now, Malad, another point in this appeal, which I'll take as a defense is that, Malad, they being a state, Malad, they cannot take two different stances. Malad, once a point has been decided against them, merely because it is not in my writ petition, they cannot take a different stance.
What to do now? 2018.
Malad, I am only.
Now he says all the trucks have been allotted.
Malad, that is Malad, their action.
Have obtained an order of interim order.
I failed. I failed.
So
I failed.
Appeal preferred, appeal
Right,
dismissed for default.
assuming we dismiss his appeal, how will you implement this order?
Malad, if they are at fault, Malad, even by way of supernumerary Malad vacancy,
no,
they will have
that
to
can't be.
allow me. Number one.
That's
Number
not the
two, Malad,
business
the
of
honorable single judge records that since 4 years have lapsed,
probably
I
that can
have
be done.
some remedy in damages also that liberty has been given to me.
You can't have it both ways. Either you go before the civil court, claim damages, or you pursue your contract.
So, Malad, they will have to Malad allow me because it's for their fault that I am out of business. They are saddling me with other neighboring states of Assam and Jharkhand, Malad, where the business is much less.
If a contract cannot be specifically enforced, your remedy lies by way of damages. You cannot have both remedies. So that to that extent, it is wrong. We need to say that, or it is up to you to elect the remedy.
Yes, Malad, the doctrine of election will apply to me. I agree to that. But Malad, my difficulty is that if I only pursue the civil remedy, Malad, it will never be adjudicated where there was a violation of the fundamental rights or not.
We can decide this legal issue and probably in the next tender, because 2023, this tender is going to, you will be accommodated, or you can be, suppose his appeal is dismissed, and we can always say that he should be treated as a preferential. But in the new tender, this issue becomes academic because you are already registered.
And already registered, and that tender, new tender, may not have the same clause at all.
This is something like operation was successful and this.
No, Malad, I was before the Honorable Court from September 2019. I was before the Honorable Court.
You should have at least sought for some interim protection.
2018, yes. September 2018, from September 2018, I was before the Honorable Court.
Keep 20 trucks vacant or something like that.
So, Malad, I failed to obtain the interim order because, Malad, at that stage, Malad, the submission was that.
One thing, sir, we cannot extend the period of tender. Writ court cannot do that. His specific stand is, in the absence of an interim order, he has allotted all these 21 tank trucks to others. As of now, there is no vacancy. And the contract period from 18 to 23 is going to end in 23 December, is it?
In September or October.
So it's almost in the fag end, probably 6 months you have got to operate. So this becomes an unworkable order, whatever you have obtained.
No, Malad, kindly two things, Malad. Firstly, Malad, it is not that I was not vigilant, Malad. I came before the Honorable Court in September 2018.
True. The court also, see, Malad, that is why when you pass a judgment, there should also be a decree, by which the order becomes implementable. So we can decide the legal issue. We can always say that, your application date is the relevant date for all purposes, because Let us assume you give the application today. Tender is invited next week. You participate in the tender. In the month of May, the Bihar authorities, RTO, grants registration. It will date back to today. So as on today, when you applied, so your registration will date back to that date. So your applying in between will not be construed as unauthorized. So therefore, to that extent, we can decide. But it's not going to help you.
Malad, I totally.
There are no vacancies, is it?
No, may I indicate one thing? It's not that his tank trucks are lying idle. All his tank trucks, may I indicate only one thing? 52 tank trucks were offered by the petitioner number 1. Out of that, 45 we were given contract under this tender. So he's agreed by 7.
7 and no, not 7.
For 50 petition number
7 and 14, yes. 21 in total.
Petition number 2.
We are concerned only of
petition number 1, 52 given. 45 we have given contract under this tender in Bihar.
Now,
he's agreed by 7. In respect of those 7, we have given him 10 contracts in other states, which he has accepted without prejudice, of course. So he is flying.
So he is not affected.
He is not. He is gainfully employed.
I am affected. I am affected.
He is gainfully employed.
Not every state. Sorry. Extremely sorry.
He is gainfully employed. Insofar as the petitioner number 1, the remaining 7
let him operate. We'll fix sometime in May.
No, Malad, it is not the same thing. Malad,
no, there's no urgency. No, a lot of urgent matters. Yesterday, PILs are absolutely. Not to say that some fellows filled up this pond, that pond, this pond, notice, affidavit, supplementary affidavit, reply, rejoinder.
My only predicament is that what they are saying.
And you are appealing for Bidhan Nagar Municipal Corporation.
But in another matter.
Now, I am going to give that letter, which we have addressed to your commissioner. The road leading from the main road to IA block. He needs to samosa. Every day there's a small accident.
Well, I'll take it up with
my secretary will give it to you.
I'll take it up with my client. But Malad, the predicament here is that Malad, the states
continue to operate in the other state.
Malad, their business is not the same at all. Malad, the business,
true, definitely.
The RTKM, that is the road trip per kilometer, for which I applied in Bihar, Malad, is much higher.
Your vehicles are not lying idle.
Yes, Malad, 21.
But your profit margin will be definitely
21
less.
of the vehicles are lying idle.
No, that's unbelievable.
Malad, there is no business at all. Their requirement is not there.
All right. We have heard the learner council. By order dated.
At least that will be at the end of April, Malad.
By order dated 29th September 2022, the Honorable Division Bench, while considering the appeal, was satisfied that the appellant has made out case for grant of interim relief, and accordingly, the order of stay of the order of the learned single bench was granted. Subsequently, the matter was adjourned on various dates, and the interim order was directed to continue. If the interim order is to be vacated at this juncture, the appeal itself will become infructuous. Therefore, the interim order is made absolute till the disposal of the appeal. The learned advocate appearing for the respondent writ petitioner prays that the appeal may be fixed, appeal itself may be heard at an early date. List the appeal for directions. Did you go 200? No urgency at all.
But only one thing, Malad, all papers before the learned single judge are already on record in the application.
We can argue with this.
So we can argue on the basis.
Paper book
No
required.
paper.
No paper.
And we can furnish an index on the next day for your lordships.
10th of May in the daily list. Since all the material documents are available in the stay petition, filing of the informal paper book is dispensed.
I'm
grateful.
What do you want to say?
Section 47 of the Registration Act relates back. That's all
what I told. So to that extent, he's got a case.
Absolutely.
He's got a case.
It presentation should be one.
Doesn't have a case on that. I didn't want to, but it doesn't, because this concept of dating back can only apply once registration is granted. It has not yet been registered in Bihar.
But he has applied.
He has
applied.
applied.
It is beyond his control.
Blood, he may not.
Neither can you do something.
No, blood. The law is to the contrary. I'll show your lordship, blood. There are specific rules. Anyway, we'll get into these questions later instead of not taking up your lordship's time.
All right.
Obligation. Thanks.
Serial number 3 and 4.
Can application can be disposed of? That's stay petition. Stay petition can be disposed of, but the stay petition should come along with the appeal. You shouldn't send it off. Stay petition disposed of, but the application be kept on record.
My lord,
The respondent, my lord.
I appear on behalf of the appellant.
Hmm.
My lord, only one indulgence I was seeking from my lords. That, my lord, there are two applications. My lord, if it can be taken up any day in the next week, because, my lord, it's a long pending matter. And, my lord, truly speaking, my lord, I could not, it's my fault, my lord. I tender my unqualified apology that I could not, my lord.
No, it's actually fixed for today.
It's fixed for
Especially
today,
fixed,
but
my lord.
What is the issue?
The issue is, my lord, I was the writ petitioner, my lord. The writ petitioner is a senior citizen, my lord. He lost his husband and he was residing in a premises. And due to financial stringency, my lord, he entered into one development agreement with the appellant in MAT 314. My lord, there was a consideration amount which was fixed, my lord, but they could not honor the promise. And they forcefully oust me and my son, who was pursuing board exam, we will giving the board exams, my lord. So I made a complaint before the police station that I want to get back into my premises. My lord, they were not doing anything, my lord. At a last resort, my lord, I approached before this honorable court, my lord. Honorable court directed to reinstate me. The police authorities reinstated me pursuant to direction of this honorable court, my lord.
But why did you file a writ petition for that?
Writ petition, my lord, I was forcefully ousted, my lord.
It is not for the, see, admittedly, there is a agreement between you and the developer.
A developer, my lord, has engulfed the property with muscles and the
if you lodged an FIR and they have not registered a case, you could have gone under 482.
So she has directed,
or you could have gone under 156(3), private complaint. How a writ court can reinstate you?
And that is also
and also directed
the
police station.
Where is your client? She is inside the property or outside?
She is at present in possession of the property, my lord.
Let her continue. You pursue your remedy elsewhere.
It's the out and out civil dispute.
Yes.
Out and out.
Only one thing, my lord, and with regard to their appeal is
in my parent high court, this writ petition would not have been numbered. The registry would have raised an objection under the rules. How a writ petition is.
We are not kind over here. But this
only
out and out civil dispute, it's a contract.
You see,
the police station was directed to lodge an FIR.
Sir, two things. One is, if there is a breach committed by the developer on any of the terms and conditions of the contract, you can rescind the contract, cancel it, or have a supplementary agreement, etc. If nothing works out, your remedy is before the civil court.
I have rescinded the contract, my lord. What they have done, my lord, I had no other place to stay.
If you had obtained a simple, filed a suit in the city civil court or in the original side of the high court.
They have initiated a suit against me in the lower court.
In fact, you should have obtained an order of injunction against him, not to interfere with your possession, not to forcefully dispossess you.
I was helpless, my lord, and that is the reason, my lord.
Somewhat familiar today's situation.
We will say that whatever is the status quo as on date will continue. Give liberty to you to either defend yourself in that suit or initiate fresh action. If there has been any excesses committed by them, and FIR has been already registered, we will direct the police to.
I am not a developer.
Then what happened? They have been arrested. They have arrested.
Now the question is, Lordship, is this, so far as
I am not
his
a
appeal is
developer.
concerned, my lord. His appeal is concerned. Lordship, I have not stated anything in the writ petition against the appellant. Here,
Suppressing this fact, my lord, this order was obtained.
Cannot seek any relief on the basis of my prayer.
You please show the prayer in the writ petition.
Prayer in the writ petition, my lord, kindly see.
Page number.
And my lord, Lordship may kindly, my lord, consider, my lord, the order passed in the present mandamus appeal on 9th of November 2021.
We'll go to one first.
Yes. I'm
see
sorry,
the
my
prayer.
lord.
Page 33, my lord. Page 33 in can number 2966 of 2020.
Mandamus, page 33.
Well, earlier can has been disposed of. Only this.
Mandamus directing the respondents 4, 5, and 6. Who are 4, 5, and 6? Commissioner of Police Bidhan Nagar, Deputy Commissioner, Inspector in charge, to take necessary steps to restrain the 7th respondent, proprietor so and so, from entering the premises. Such a prayer is not maintainable. Mandamus directing to police protection, so that the petitioner can enter into the premises. This the police can't interfere except only under circumstances if you have a civil court order. 3. Directing the respondents 5 and 6 to investigate the complaint. This has become infructuous because now charge sheet has been laid.
But on the basis of the order passed by the writ court, my lord, they have lodged an FIR.
Therefore, as of now, we will say that the status quo with regard to possession may continue. Both parties may agitate their respective rights, liberties, etc. before the appropriate.
Great.
That is the best.
Yes.
This intra-court appeal is directed against the order dated. Where is the order of the? It's here. Order passed by
Order by this division bench, my lord.
No. Order single bench. Dated.
Page 160.
Single bench, my lord. Page 159.
Dated 14th
14 February 2020.
The said order was passed in a writ petition filed by the respondent here, first respondent here. Just now we showed. I didn't put the slips. The index is not there. Oh, where is the writ petition prayer you just now showed?
Writ petition page 33, my lord.
Page one, in the application for stay at page, it starts from page
19.
Page 30 is up there.
Can number 2966 of 2020.
No. In a writ petition filed by the first respondent herein, praying for the following reliefs. A. For issuance of a writ of mandamus to direct the Commissioner of Police Bidhan Nagar Police Commissionerate, Deputy Commissioner of Police Zone 1 Bidhan Nagar Police Commissionerate, and Inspector in charge 6th South Bidhan Nagar Police Station to restrain the 7th respondent, the appellant in FMA number 986 of 2021 from entering into the premises at block CB, plot number 13, sector 1, Salt Lake City, Kolkata. B. Issuance of a writ of mandamus to direct the police authorities to render necessary police protection to the writ petitioners so that the petitioners can enter into the premises freely, so that no hindrances and impediment can be caused by musclemen and bouncers deputed by the 7th respondent / appellant in FMA number 986 of 2021 in the vicinity of the said premises. C. Mandamus to direct the police authorities to investigate into the complaint made by the writ petitioners and to file a report before this court. The learned single bench by the impugned order had virtually granted all the relief sought for by the writ petitioner, and it is stated that the writ petitioner is in possession of the property in question. Admittedly, the genesis of the dispute is based upon an agreement entered into between the writ petitioner and the appellant in FMA number 986 of 2021 concerning the subject property. There are inter-se disputes which are purely civil in nature. Therefore, we are of the clear view that the prayer sought for in the writ petition, that the writ petition was not maintainable. We support such conclusion with the following reasons. The first prayer sought for by the petitioner, as mentioned above, is seeking to restrain a private party, namely the 7th respondent in the writ petition and the appellant in FMA 986 of 2021 from entering into the premises in question. Such a relief cannot be granted in a writ petition, and the remedy of the writ petitioner is elsewhere and not before a writ court. The second prayer sought for by the writ petitioner is to direct the police authorities to give police protection so that the petitioner can enter into the property in question. To enable the authorities, enable the police authorities to give police protection, the writ petitioner has to establish breach of peace. Admittedly, the genesis of the dispute is a civil dispute, and the police cannot enter into the realm of a civil transaction unless and until a competent civil court has issued a specific direction based on interim orders or a final judgment and decree. Therefore, to seek for issuance of a writ of mandamus without being supported by any order passed by the civil court would not be maintainable. In any event, the prayer sought for has worked itself out, since pursuant to the directions issued by this court, the writ petitioners have been put in possession. We therefore deem it appropriate that the said status quo should not be disturbed, leaving it open to the parties to agitate their rights.
They are in part possession.
Before the competent civil court. With regard to the third prayer, the same has become infructuous, as it is mentioned that the investigation has been completed and the final report has been filed, and therefore prayer C has become infructuous. In the light of the above, while preserving the status quo with regard to the possession of the petitioner in the portion of the said premises, we leave it open to the parties to agitate all their rights before the appropriate forum. We are informed that the appellant in FMA number 986 of 2021 has filed a civil suit, and the same is pending, wherein the writ petitioners have been impleaded as defendants. The writ petitioners are entitled to defend the suit by raising all factual and legal contentions, and any observation made in this order will not prejudice their rights in those civil proceedings. Similarly, the writ petitioners are at liberty to work out their rights if, according to them, the agreement between the parties are no longer in force, and we do not wish to make any observations in this regard, as it may impinge upon the rights of parties. With the above observations, the appeals stand disposed of. Thank you.
Milord, only one thing I should indicate, Milord, that they had filed the suit upon instructions from my instructing advocate.
You just said you filed the suit.
I filed one missed case. And
against the order passed by the Lordship, I was filed the suit for eviction, my lord, because they were trespassers.
All right. Then you have to mark.
They were trespassers, and they are not in possession.
We are in possession.
And they have
very good, very good. 10 people can argue.
Sorry.
It is brought to our notice that the writ petitioners have filed an eviction suit in which the appellant in FMA 986 of 2021 is a defendant, and the said appellant has filed a miscellaneous case in the said suit. We leave it open to the parties to agitate their respective stand before the civil court, raising all factual and legal issues. That's it. One at a time, sir. Chartered High Court. Chartered High Court. One at a time. The magistrate court then.
prayer, he has sought possession.
Injunction order is still
dictated the order.
He's asking for
You are
possession.
aggrieved. Supreme Court. Please call the next case. Thank
Serial
you.
number 5.
Your Lordships,
All CAN applications disposed.
with your Lordship's permission, I am a practicing advocate of the Honorable Court. I am not a part of item number 5, Your Lordship. I am feared to crave leave so that I can file this application. Your Lordships have fixed a matter at 12 o'clock today.
Which one?
Which was item number 1. My application is almost related to the matter, but my prayers are
No,
different.
in fact, similar requests have been made by 4 or 5 advocates.
Your Lordships, their prayers
we
were
have said
same.
What we have said is, we are not granted leave to anybody. We will hear you. You come at 12 o'clock.
Your Lordships, I will come. In the meantime, I'm filing. If
No.
Your Lordships feels, because my prayers are
No, we are
different from
not.
the prayers made by
Multiplicity
them.
will
Your
avoid.
Lordships.
Huh? Please come at 12.
Grateful, Lordship.
Serial number 5.
In this matter, I am appearing on behalf of the appellant writ petitioner, my lord. On earlier occasion, this honorable court has been pleased to grant the leave to file supplementary affidavit
What is the matter?
annexing the writ petition, my lord.
Where is the writ petition?
My lord,
Writ petition is not here. Huh? Interesting.
the lordship matter relating to inaction on the part of police authority.
Yes, the court says, in such circumstances, further interference by writ court is not called for. As and when the petitioner lodges a complaint to the local police, no doubt the local police will take. You have filed a complaint?
Yes, my lord, but
what
not
happened here?
before the local police authority.
What
Why,
happened?
my lord? I am satisfied, my lord. My lord, kindly come to the page, annexure P7, page 48 of the supplementary affidavit. Annexure P7 of the writ petition, supplementary affidavit, my lord. Kindly, page 48.
Page 48. Yes. That is order dated 21st February.
Lordship. Page 4.
Page 48. There are 3 page numbers.
Annexure P7 of the writ petition, my lord, kindly. Representatives. P7 of the representatives.
Page 54. Supplement. This one.
Yes, my lord.
Lordship will go through.
My lord, I made representation before the superintendent of police, my lord. I was beaten by the private respondent, my lord. Then the local police authority rescued me and brought me to the police station. Then they treated me and they again brought me to the police station. And in this police station, the local police authority threatened me. You do not file any complaint against those the private person. You hand over your properties. My lord, matter started from in the year 2009, my lord.
Who is for the police authorities?
I'm for the state, my lord.
My lord. What is your instruction on that?
My lord, sorry.
Lordship, order was.
No. If he has lodged a complaint, the police authority should investigate it. If according to them it's a civil dispute, they can refer it as a mistake of fact.
It is a totally civil dispute.
So you refer it, you give him a referral memo, he will challenge it. And why he is detained in a police station, threatened and other things, then your policeman has to be suspended.
Lordship, order was passed in the year 2021. Kindly see the memorandum of appeal, my lord.
Now, what is the present position?
My lord, I cannot enter in my village. This is the position, my lord. My lord, kindly see, I made representation to the superintendent of police and all the higher authority.
Then at least the superintendent of police can consider.
And all the higher authority.
It is like excommunication. He can't enter the village.
Lots of report may be submitted, my lord.
The petitioner.
Otherwise, representation may be considered by
within a time frame.
Okay.
So he says he can't enter the village. That is a very serious issue.
He was also assaulted. That is the complaint.
Look, every day he's going to his blood. A very small, look, he has now. His other day, let's say I'm staying elsewhere. He is going to the small heart is there. He's going to the there is no scope even to cook.
All right, his representation could have been considered. The superintendent police could have ordered an inquiry. Matter could have.
That's certainly not effective order.
No. The learned single bench says if he lodges a complaint, they will consider. But he has not considered. All right. The writ petitioner has been dissatisfied with the order and direction issued in the writ petition dated 4th August 2021 has filed the present appeal. The petitioner sought for what is the prayer and the declaration? The prayer in the petition was to issue a writ of mandamus to direct the officer in charge of Mohanpur police station to take steps in accordance with the based on the complaint made by the petitioner on 13/3/2020 and 7/7/2020. And to direct the said police to ensure that nobody threatens the petitioner so that he can peacefully enter the village at Padima under police station Mohanpur and carry on his daily functions. The learned single bench had disposed of the writ petition by observing that if the petitioner lodges a complaint with the local police, will take appropriate steps with regard thereto. The petitioner would submit that the learned writ court ought to have issued a positive direction to the petitioner, to the respondent police, to investigate into the matter based on his complaint. The petitioner alleges that he is not able to enter the village. However, you are appearing for?
Private respondent, 7.
However, the learned advocate for the private respondent submits that the petitioner is daily entering the village and he is using the hut which he has put up in the village. These disputed questions of fact cannot be gone into in a writ petition. From the annexures to the supplementary affidavit dated 13th March 2020.
7th July 2020.
No, supplementary affidavit. Annexure filed along supplementary affidavit dated 28 January 2020. We find there are two representations given by the petitioner to the Superintendent of Police Paschim Medinipur dated
There are two 13th of March 2020.
13th of March 2020 and another
7th of July 2020.
And 7th of July 2020. Those representations are still pending. Therefore, we dispose of this appeal by directing the Superintendent of Police, Paschim Medinipur, to take on file the said representation / complaint and forward the same to the appropriate police officer to conduct a detailed investigation into the matter and, if necessary, make a spot inspection of the area and thereafter proceed to take action in accordance with the law. This direction shall be complied with within a period of 4 weeks from the date of receipt of the copy of this server copy of this order. Next.
Serial number 6.
I'm your sign person.
Would I appear for the state respondents, Milord?
I would question the maintainability of this appeal.
The senior counsel has been always with me altogether from 21, and he's saying, "Who are you?"
You need not argue with him. You address the court.
I'm telling you, sir.
You address
That is
the
what.
court. What was the writ petition for?
So the writ petition is that everybody wants to buy my properties by force and force signatures. Means throwing me in the police station first by a 144 and then taking signatures for father, which I told my father, please don't do it. He's a doctor, eye surgeon, he was. He's no more, he passed away in 2018. My grandfather and our properties are massive properties in Behala, South 24 Pagnas. And these people, the state has been after the, I'll just show you, sir. So these are the documents to copy. So we were the founders of light manufacturing in Patna and the founders of the fan in India, in Asia. We used to export till Germany. And we had been only after pre-independence, 1930. And after that, they were only threatening us, my grandfather and all, by bombs and all, everything. When our two factories got closed, one in Behala and the J Engineering Lake Gardens. It was part of us, then we sold it to DCM. So I put a petition in Justice Mantha's,
what was the writ petition for?
So this is a writ petition for property in Behala where they wanted to acquire.
Prayer in the writ petition, page number?
The prayer is that the club is with the police and they jointly put in 40 people inside at night.
29.
On
Page 29.
in the night to force me signatures and leave the property by a molest case. I was under 2 molest cases and 1 assault and 1 which I have 1,420.
No, the prayer was mandamus to commanding the respondents to show cause why Naburna Sangha nearby and patients were shifted to nearby Salvation Army home.
Yes, sir. So
a free camp. They went house to house and talked negative of his brother with the help of local leaders, clubs, etc.
Yes, sir. So this is my father, an eye surgeon. Our patients were pushed from the hospital to a Salvation Army. Just imagine how forceful they were. And this is the first eye hospital in the district, sir, where I stay now today. It's Krishna Bhavan. They've been hounding like anything, sir, at this age. If they
no, what do you want? What is
I want a relief so that they don't.
What relief? In a writ petition, we can't put you in.
So they've even removed the original deeds and they're mutating all the properties nearby.
So you approach the civil court, obtain
civil court. There's one brother who's the black sheep. We were all well educated. He's clubbed in with the local club.
So therefore,
told,
it is a family dispute.
I agree, sir. It's family dispute.
But suppose there is a threat to your life and you have lodged a complaint seeking police protection, etc. Police have not acted. You can file a 482 petition or probably may be justified in filing a writ petition. But how to go into all these?
So you see 3 deaths of my aunts and uncle has been taken indirectly by the clubs.
We're very sorry to hear that information. But then as a writ court, we can't.
Some relief has to be given so that I don't.
We can make an observation that you can always approach the civil court and obtain appropriate orders.
Civil court, the judges, I'm sorry to speak, sir, nothing works there in Alipur court, sir. Nothing works there in Alipur court.
Sorry,
50 lawyers pushed me out. 50 lawyers pushed me out. And they wanted again the forced signature in the bar library. And then I got COVID. Just imagine how much cost I'm incurring with no income. My 2 hospitals being closed fully. They send patients and again take back the money. That is the thing going on. It's lucky that I have properties in Delhi that they fund me for my living. Otherwise, I would have been bankrupt. And some landed properties in Calcutta. There also, sir was there in the other court.
No. What the direction issued by the learned single bench in the impugned order is perfectly in order.
I agree, sir, but give me some relief so that as Mr. Mantha has given me, that there should not be any disturbance. You see Mr. Mantha's order, sir.
That's in a different.
It's not the impugned order.
That's not the impugned.
This is not the impugned order, but this is related to writ. Writ is got a very big aspect in our lives, sir, in Constitution of India. This is what I'm learning, sir. They're doing crime against me, car accidents
And
here.
what is the Kolkata Municipal Corporation doing?
So the Kolkata municipality is doing false mutation, sir. False mutation, sir. And the Supreme Court has said that directly the mutation has no power to do title. And that has
Even Justice Manta's order says your remedy is before the civil.
No, sir. No, sir. So you read the second order. So next to final order on 15-2, sir.
Yes, I'm reading that.
So you read fourth, fifth pages. He's referred liberty to file a writ in the against the corporation in another court. And after that, he's given actions to do criminally. See the third and fourth paragraph. Now the banks.
The Harry Street Police Station may be looked into point of view of the criminal law, and appropriate suitable steps may be taken by the.
Yes, sir. The only thing is the signature, sir. If I sign, they're the owners.
Sorry,
State
sir.
is the owner, sir.
This intra-court appeal.
If you ordered, your lordship should consider once, because that was passed by Justice Prasad.
Yes.
Your lordship has got that order.
25th of June.
Yes.
That has to be stayed.
That is exactly.
And that has to be stayed, and the club has to be fined.
Sorry.
Sir.
This intra-court appeal by the writ petitioner appearing in person is directed against order dated 25/6/2021. The writ petitioner filed the writ petition was filed for the following prayers. The prayer is here in this order itself, improved order.
So with excuse, this property is also under will. My property is all under will. So I get. So
The learned single bench, after elaborately hearing the petitioner appearing in person, held that the petitioner seeks to protect the possession of an immovable property, and therefore he has to seek such a relief before the civil court. Agreed by saying the petitioner has preferred the present appeal. We have elaborately heard the petitioner appearing in person, and we find that the order passed by the learned single bench is perfectly justified and in order, since the dispute is essentially a family dispute concerning properties. In fact, the petitioner appearing in person made several submissions, pointing out as to how one of his blood brothers has joined hands with another set of people, and he has been evicted from the property in question.
No, sir, I've not been. I stay there, sir. I stay in my property.
Has joined hands with another set of persons and acting against the interest of the writ petitioner.
Which is under a will, sir.
Further, it is submitted by the petitioner appearing in person that there is a will executed by
my
his,
grandfather,
by
the
the
property
grandfather
owner,
of the
grandfather.
petitioner in respect of the said property. All these issues cannot be agitated in a writ proceedings. Therefore, therefore, while dismissing and affirming the order passed by the learned single bench, we grant liberty to the petitioner to approach the appropriate civil court for necessary.
So just one direction, just that nobody takes 4 signatures, sir. Nobody in the police station or anywhere.
Thank you.
If you could.
Thank you, sir.
Okay. Much please. Sir.
Thank you.
Serial number 7.
My lord, I am for the appellant. Oh, there is a delay of 103 days.
You are for the
appellant bill.
I'm for the
appellant means writ petitioner.
Private respondent, writ petition.
I'm for the state.
Private respondent in the writ petition. Here, my lord, appellant.
And what is the direction? There is no direction against you. All that they say,
yes.
Diamond Harbour National Highways Division will cause an inquiry into the construction made by your client. In the event they find construction is on the land belonging to any of them, urgent steps may be taken. They will put you on notice, let them inspect.
No, everything. What happened, my lord? He has filed, my lord, writ petition, stated that his ingress and egress has been obstructed. But fact remains that inquiry report shows his ingress and egress is not obstructed. My lord, he is suppressing that fact, so my lord, writ petition filed before the learned single judge. Otherwise, my lord, public land, he has to file, my lord, public interest litigation. whether learned single judge sitting residuary jurisdiction, whether pass such an order in respect of public land.
No, we will modify the order by saying that no positive direction can be granted. If according to the writ petitioner, there is some unauthorized construction, the appropriate authority will look into the matter. That's all.
That's true, but whether writ petitioner has a right to put this question or file this writ petition.
If it is an illegal public land, if it's an illegal construction on a public property, he can file a writ petition. But if there is a civil dispute between both of you, writ petition is not maintained.
No, he has not filed public interest. He filed
not
writ
required.
petition.
It
But
is his
that's
personal
true,
interest.
but what happened,
Rightly, it's classified as a
These,
group nine.
these writ petition, these private respondent, they are originally, they are a private land. They are sitting there last 40 years. They have construction. Now, subsequently land has been acquired. No notice has been acquisition was
That is a remedy is elsewhere.
Yes.
If the National Highways has not issued notice and they have unauthorizedly acquired the land, you should have challenged the acquisition process.
Not only that,
This order will not.
What happened, Government has allotted house under the Abbas Jojana, Bangla Abbas Jojana.
They will inquire
That
into
house has been constructed upon that land. Now, if government is demolish that, then government will use-
government won't demolish without hearing you. What is your instruction?
No, my lord. Assistant engineer, my lord, they have filed contempt application. In connection with the contempt, my lord, the assistant engineer National Highway, my lord, Division 1, they have passed order, demolish the entire. Not only
you
that,
challenge that order.
my lord, that order is my lord, statutory appeal lie before the my lord, district magistrate.
You file appeal, you file writ petition.
That's true, but my question is, my lord, whether writ petitioner initially, my lord, writ petition file, they have stated that their ingress and egress has been obstructed.
Well, no.
If my lord, if my lord,
direct-
this ingress egress is not obstructed actually, whether my lord, suppressing this file writ
Where is
petition.
the order passed by the
Yes.
authority? National Highways.
Also, the total, he is admitted that he is the
No, no.
encroacher of the
My
national
lord,
highway.
encroacher, my lord, National Highway, if you lord
Already
see,
admitted.
there is my lord, thousands of encroacher. Thousands of encroacher.
এটা তো
My lord, contempt proceeding, my lord, 17 March, my lord, Justice, my lord, Mantha has passed order that demolish all.
No. The block land and land reforms officer
Yes.
has passed an order. You challenge that order. Notice of removal has been issued. And notice has been sent by speed post, returned with the comment deceased. A letter of the postmaster Alipur returned back the comment deceased. Hearing held on 14th in chamber of the executive engineer.
Parties appeared. Well, how much this is to how
petitioner
parties
was
appeared.
present there.
So how appeared? Well, whether postal authority was note has been given.
Lordship, petitioner was present at the time of the hearing, my lord. My lord.
No, have you passed an order?
Lord, yes.
On what date? Where is the order?
Yes.
29 March.
29 March. Kindly see. 29 March.
My lord, in pursuance of your lordship's, the order of the learned trial judge, the notice was issued. They have participated, and thereafter on 29th March, my lord, two orders I have.
During the pendency of this
Your
appeal,
lordship, kindly see.
my lord,
They
have
on
passed
29th
orders.
March
You
2000.
challenge this order, sir.
No, my lord,
My lord,
my
thereafter
question
you
is,
have
my lord, whether my lord, learned single judge, my lord, sitting
That we will
simply-
deal. That we will deal and pass an order.
Not only that, my
You
lord,
challenge this
if-
order.
If the my lord writ petitioner, my lord, suppress the material fact, they have filed previously 147 for ingress and egress.
After
But that matter has been dismissed. A report shows that there is no ingress obstruction of ingress and egress. That has they have suppressed. Well, kindly see my lord, the report of the my lord, BLRO. So, my lord, suppressing fact, my lord, they have demolished to my lord, the poor people who has my lord, last 40 years.
My lord,
ago, they are
thereafter
sitting
your
there.
lordship, kindly
Yes, sir. We have heard you. This
Not only that,
intra-court
my lord,
appeal-
government allotted house
This-
under the scheme.
This intra-court appeal is directed against order dated 30th
Thereafter
November
contempt is
2020
there.
Wait, 30th November 2021, passed in WPA number 2249 of 2021, filed by the respondents here. The appellants are the private respondents in the writ petition, namely respondents 9 to 12. The allegation in the writ petition is that the appellants have encroached into a land belonging to the national highways and put up construction, and the ingress and egress to the writ petitioner's property has been affected. The learned single bench has disposed of the writ petition by directing the authorities of the National Highways Division to inquire into the matter, and if there is any encroachment, steps should be taken to demolish the said construction and construction. The learned advocate for the appellant would vehemently contend that the writ petitioner is guilty of suppression of material facts and could not have approached the writ court by filing a writ petition by classifying the same under the residuary classification. Further, it is submitted that the appellants are in possession of the property for over 40 years and they have also put up construction. The learned government counsel as well as the learned advocate appearing for the
and recently government allotted house under the Pradhan Mantri Awas Yojana scheme.
The
that house also
government
constructed.
Government counsel and the learned advocate appearing for the writ petitioner submitted that in terms of the directions, inquiry was conducted and an order has also been passed by the executive engineer of the National Highways Division 1, Public Works within brackets Road Directorate, dated 29/3/2023, and there is an earlier order, 29/3/2023. In reply, the learned advocate for the appellant would submit that the house had been the construction put up by the appellants are under a scheme of the Government of India. In any event, an order having been passed by the appropriate authority, the direction issued in the writ petition has worked itself out. Therefore, the only remedy available to the appellant is to challenge the correctness of the order passed by the executive engineer, National Highways Division 1, Public Works Roads Directorate, dated 29/3/2023, or any other order that would have been passed thereafter. With such liberty, the appeal stands disposed of. Next.
Till disposal of the statutory appeal, no coercive action will be taken by the court.
When you will file the appeal?
Yes, 29 order has been passed, 4th has been filed. Last day has been
the
filed.
learned after the
What is the period of limitation under the statute? You have filed.
Yes.
No, your lordship,
29 March order has been passed. 4th April
no statutory appeal.
after the order was dictated, learned advocate appearing for the appellant submitted that an appeal has been filed on 4th April 2023 against the said order dated 29/3/2023. If the same has already been filed, the said appellate authority shall consider the appeal and dispose of the same in accordance with law.
May I indicate one thing, my lord, I don't appear in this matter because I am there in the writ proceedings. Lord, the learned single judge has directed filing of the appeal before the district magistrate. Now, the act provides.
Not before DM.
Not before DM, before the tribunal. But they appear to have preferred the appeal subject to correction before the district magistrate.
File it before the tribunal. DM doesn't have power.
I will kindly indicate
So
that.
there is a order.
Then the last
the contempt proceeding, there is a order.
Stop with that. Yes,
I will kindly indicate the appeal will be before the tribunal.
It is submitted by the learned
tribunal is not functioning in the West
Then
Bengal.
he can come to the writ court, my lord.
Indirectly, he is telling where you have to go.
As your lord say. As your lord.
You take the hint from him.
Yes. What will single judge direction was there?
Also, Government counsel that the appeal before the district magistrate filed by the appellant is not maintainable, as he is not the competent authority. If that be so, the district magistrate may either return the appeal memorandum to the appellant or forward the same to the appropriate appellate authority.
We remain grateful, my lord. We remain grateful.
With due intimation to the appellant. Yes.
One thing I am just pointing out now. Just one thing. For non-compliance of the order, contempt proceeding was there. In the contempt proceeding, the contemptor appeared. They have submitted report by saying that yes, order has been complied.
We have affirmed the order. That's
yes. And before the contempt proceeding, they have said that we will prefer appeal.
Next.
Now,
AG is not at come. No? Let the AG come. You call only.
Serial number 8.
May I please, your lordship, in this matter, my lord, I appear for the appellant, my lord. So the prayer of the appellant is this, my lord. Interest for the period or delayed payment of dependent pension. So, my lord, kindly come to page 60. That is the order.
Now the direction has been issued to pay the arrears.
Yes, arrears have been paid. Arrears have been paid. My lord, for arrears for the period from 24th October 2015 to 19th September 2018, 2018, that, my lord, the interest not paid. And that was paid delayed in after this read application.
That was
No, wait. Now, what was the reason for the delay? See, interest is payable. There are two types of interest.
Yes.
One is if that a particular statute interest is payable, that's statutory. The second interest is common law remedy, where the writ court can say this person has been put to lot of harassment. Therefore, on this amount, 8% simple interest.
Yes.
And the learned, unless and until you are able to make out a case of failure on the part of the authority to take action, appropriate action, how do you justify a claim for
They
it?
failed to take appropriate action on granting your dependent family pension because only after moving writ application before this honorable court that family pension was granted. But, my lord, not for that period.
Statutory interest is
Lordship, my only
Not
prayer,
for that period.
Lordship, in the writ petition, Lordship, there was no prayer for pension. The scheme, Lordship, this is a freedom fighters pension. This is not a
freedom
pension,
fighters pension. No, sorry.
Therefore, that is not,
No
we're not
interest is
entitled,
there.
Lordship. The
This
scheme does
intra-court
not
appeal is
qualify.
directed against the order dated 28th February 2022, WPA 20973 of 2021. The writ petition was filed for sanction of freedom fighters pension. The learned writ court has disposed of the writ petition by directing that arrears of the freedom fighters
And all
pension
payments
shall be paid for the period from October 24, 2015 to August 2018. It is admitted by the learned advocate for the appellant that the arrears have been paid. Though there was no specific prayer sought for in the writ petition for payment of interest, it appears that an oral submission was made. However, the court was not however, the learned writ court was not inclined to grant interest for the alleged delayed payment. Admittedly, the payment of pension is under a scheme.
Yes.
And the appellant have not made out any case for failure on the part of the authorities to grant the arrears of the pension at the appropriate time, the claim for interest cannot be sustained. Therefore, we find no error in the order. Further, we find that the writ petition was filed in the year 2021. Thus, the appellant writ petitioners themselves have contributed to the delay. Therefore, we find no reason to interfere with the order passed by the learned single bench. Appeal fails, dismissed. Sorry, next. One more matter.
Serial number 9.
My lord, I am appearing on behalf of the state respondents.
I am appearing for the petitioner, my lord. The writ application was filed alleging, my lord, that the police authorities, despite several complaints being made, have not taken any action in accordance with law. Paragraph 8 and 9, I have stated, my lord, the acts done by the candidate respondent And with regard to the complaint mentioned in paragraph 8 and 9, I made a prayer that the police authorities should take up steps in accordance with on the basis of complaint. Now, my lord, the writ court has firstly dismissed it on the ground that there is no urgency involved in the matter, although the matter was filed 2 months ago. And I mentioned the matter so that it can be heard out. Even for 2 months, the matter was not taken up. And on my mentioning, the matter came. And a cost of 3,500 is imposed because I mentioned this matter. That's the one reason. The second reason is
the cost
that, leaving aside that part, that's
That
material. The second part comes in that it was submitted on behalf of the state advocate that in respect of one complaint, a charge sheet has followed. There was a confusion whether charge sheet has been filed or not because I ascertained it and find it's true. My learned friend is right enough in saying that insofar as one complaint which is recorded in the order itself, a charge sheet has followed. So far as other complaints which forms part of the writ application, it is silent on the part of the state advocate as well as.
Why are you begging before them?
I'm sorry.
If they are not registered a complaint, under the criminal procedure code, there is a remedy.
156.
Why you? In fact, the writ petition itself was not maintained.
Absolutely, madam.
You could have lodged a private complaint. You would have gone under 156(3) before the magistrate. 20 complaints you have lodged, and 20 writ petitions you will file. We are not here to do that.
No, it's not that.
We will give you liberty. Suppose they have not registered an FIR on preliminary inquiry, on a petition inquiry, they find it's a civil dispute, mistake of fact. Then you're not as if there no remedy is available. A lot of remedies are there for you.
Your lordship is absolutely correct.
We will delete the cost and give you liberty to go before the appropriate.
May I submit this? Taking into the complaint as a whole, it will leave no doubt about that the police
We can't
authorities.
go into the merits of the.
Only one thing which I may request your lordship to take into consideration. My client is 76 years old. What has happened? Cancer patient, 76 years old. The complaint is that he entered into a work contract with the private respondent. Under the work contract, there is a dispute what amount he has paid or there is some liability payable. This is the dispute. Now, my lord, the private respondent have gone into his property, locked the property, taken possession of the flats, thrown him out from the property, and in that flats, they have entered another person's. And I requested the police authorities to make a complaint. When I made a complaint, the police is insisting to take action me, rather taking any action against the offense complaint.
All right. In one complaint, charge sheet has been filed.
Yes.
How many more complaints are pending?
I have made a list.
4, 5, 6, 7, 8, 8 complaints.
My lord, there are 8 complaints.
All right. What have you done, madam, on those?
My lord, may I submit, my lord? My lord, these complaints which are being now narrated before your lordship, my lord, these are all absolutely same with respect to the subject matrix. My lord, there is no distinction between. My lord, taking as
to refer the complaint.
My lord, what has happened? My lord, we had registered because my lord kindly sees there is no cognitive prima facie, my lord, to register.
No, we are
My
not
lord,
here.
there has to be a
We are not
cognitive
advising your police authorities to do this in this fashion or not. You have received the complaint, you inquire into it. If you see it is of civil nature, refer the complaint. Why do you keep it on your file?
My lord,
And that
these
is
are all basically a representation referring to the earlier date. That's how
you return everything. Why did you accept it? You return everything so that he will go before a different form.
And my lord, what we have done, my lord, with respect to the last, my lord, the accumulated FIR was registered on 1st of July 2019. And based on that, my lord, we conducted the investigation and also submitted a charge sheet. Now, prima facie, my lord, when they came up in this appeal, their allegation was to the effect that the charge sheet has not been submitted, and that's an absolutely erroneous statement which was recorded by the
he
court.
admits.
Now he is standing out of it, my lord, because I have submitted the requisite thing. The next part is that, my lord, the reason as to why this was held, because in that court, my lord, there was, my lord, in case of extreme urgency, a liberty was given to the concerned petitioner advocate to mention the matter and get the matter done. My lord, so this is the reason why perhaps this cost has come. My lord, however, my lord, that is absolutely your lordship's discretion. I am not in the way. But my lord, with respect to the whatever complaint they are saying, everything is accumulated in this complaint. And my lord, that is also landed with charge sheet. Now, if he is really having any grievance, there is a provision under the Code of Criminal Procedure to go for Narazi petition, which they have not availed. Instead, my lord, they're filing appeal, making aspersions against the judges, counsel, I don't know what. Thankfully, my lord, now he is withdrawing it. So I have nothing more to say.
How can there be an aspersion against the judges and
All right,
counsel?
we have heard you, sir.
I say that one only was made, other
All right.
complaint.
This intra-court appeal by the writ petitioner is directed against the order dated 18th May 2022 in WPA 4962 of 2022. The said writ petition was disposed of by imposing cost of rupees 3,500 on the writ petitioner. The sum and substance of the grievance of the writ petitioner is that several complaints have been lodged by the writ petitioner to the Howrah police station, but no action has been taken against any of those complaints. Rather, the writ petitioner has been continuously being harassed by the private, which respondent? By the
678.
By the respondent 6, 7, and 8. And it is alleged that they have dispossessed the writ petitioner from the property and put certain third parties in possession. The learned government council on written instruction submitted that based on the complaint given by the appellant, investigation was done and charge sheet has been laid on 29th February 2022 for offences under section 448, 427, 323, 506 and section 34 of the Indian Penal Code. Though initially, the petitioner contended that no charge sheet has been filed, during the course of argument, today during the course of argument, the learned advocate for the appellant admitted that in that said case, charge sheet has been laid. Full stop. The grievance of the appellant is that there are 8 more complaints which are still pending with the police. The learned government council submits that all the facts are identical and after investigation, charge sheet has been laid. And if at all the appellant is aggrieved, he has to avail the remedies available under the provisions of the Criminal Procedure Code. The submission made by the learned government council is well-founded. If the appellant is aggrieved by the inaction of the respondent police, it is well open to the appellant to avail the remedies which are available under the Code of Criminal Procedure. Therefore, no further direction is required to be issued in the writ petition, and the observations made by the writ petition, as already a charge sheet has been laid in respect of one of the complaints lodged by the appellant. Therefore, we find no grounds to interfere by the order passed by the learned single bench. However, we are considering the facts and circumstances of the case, and that the appellant is a senior citizen and suffering from certain illness, the cost imposed on the appellant stands deleted without.
Much obliged.
Yes.
One line, if your lordship may kindly add. The one in respect whereof charge sheet has been issued.
Writ itself is not maintainable. We would have dismissed it.
This will, my lord, this will not come as embargo on the part of the state to take action in accordance with other complaint, because it closes one line that so far as the one in respect whereof charge sheet has been issued, it covers. In respect of others, there is no.
You know better.
But one line. This will not take the authority from taking in accordance with law in respect of others.
Thank you.
Update site release fixed at 12 p.m. Serial number 1.
But one line that at least police should inquire into the other complaints.
Thank you.
And cost is deleted so far as the.
Cost has been deleted, Mr. Gupta.
Cost deleted.
Yes, sir.
File.
Lord, kindly takes my lord the last but third paragraph at page 8. That covers it. Having regard to the applicant.
Yes.
My lord, I have, my lord, managed to, my lord, discuss, but unfortunately, my lord, not face to face, because, my lord, there's a blockade there also, my lord, they couldn't come. But, my lord, may I indicate, my lord, first, my lord, may I hand up, my lord, the 27 terms and conditions, my lord, which have, my lord, been framed, my lord, by the Kolkata police.
Yes.
আছে তো তোমার প্রেজেন্টলি চাই তো সম্মুখে দাও
But it says car, tableau, etc. There is no ban on.
No, my lord, your lordship's right, my lord. Your lordship asked me. I said, my lord, on foot, my lord. Some vehicles go in, my lord, which have a tableau. I checked on that, my lord, but not necessarily, my lord, for tomorrow's procession. My lord, in Ram Navami that happens, in Durga Puja it happens, my lord.
Right.
My lord, so my lord, that
the other people are on foot.
Yes, all others, my lord, have to be on foot. It's not, my lord, that there's a car rally or there is a motorcycle rally or, my lord, a cycle rally.
I think some tweaking is required.
My lord, I have, my lord, made 15 points. My lord, I've discussed, my lord, with, my lord, the concerned authorities. My lord, all 15 may not be possible for them now, my lord, but I'll, my lord, for future also, my lord, we'll, my lord, certainly, my lord, require. My lord, first thing, my lord, which I would, my lord, suggest, my lord, is, subject to your lordship's approval, is, my lord, that whatever terms and conditions, my lord, are imposed, my lord, once an application is made, my lord, the person applying and the organization concerned, my lord, must give a declaration, my lord, to the effect that, my lord, the organization, its office bearers and the applicant will be liable, my lord, for any breach of the terms and conditions of, my lord, the permission. And, my lord, if, my lord, it is found that owing to such breach of terms and conditions, my lord, that any damage to life, property, or, my lord, any bodily harm is, my lord, concerned, my lord, they would also be, my lord, responsible. My lord, that is, my lord, the declaration which your lordship, my lord, indicated right, my lord, upfront, my lord, in today's hearing, so that accountability, my lord, is also there for, my lord, persons who are applying and persons who are, my lord, going to, my lord, take out the procession. Second, my lord, is, my lord, on the participants. If your lordships look at, my lord, clause 2, my lord, number of participants should be in accordance with declaration in the application. My lord, the police, my lord, should have, the authorities should have, my lord, the, my lord, authority, my lord, to restrict, my lord, the number of participants, my lord, your lordships, because we are looking at preventive steps now. Because, my lord, other than, my lord, the extent of the route, my lord, also, my lord, preventive steps in, my lord, what appears to be, my lord, a charged atmosphere for whatever reasons. My lord, particularly keeping that in mind, my lord, that this, depending on, my lord, the route to be followed, my lord, there will be, my lord, discretion on the police, keeping, my lord, law and order situation in mind to determine, my lord, how many participants should be there. And, my lord, they have to accept that. Now, my lord, the second, my lord, is, my lord, the starting time and, my lord, the end time of, my lord, the procession, which will be indicated, my lord, has to be strictly follows. It, my lord, cannot go beyond, my lord, that, my lord. My lord, this is, my lord. Then, my lord, your lordships, my lord, made a suggestion with regard to barricading of the entire route. My lord, that may not be possible immediately, my lord, my lord, because, well, immediately it may
Time
not.
is too short.
Yes, time is too short, my lord, and we'll probably need many more barricades, my lord. Close to, my lord, 2,000 applications have been made, my lord, for, my lord, where I have, my lord, something to say, my lord. So, my lord, on barricades, my lord, I leave it to your lordships, my lord. I was thinking, that's my suggestion without, my lord, consulting, my lord, taking any consent. My lord, my suggestion subject to your lordship's approval, but kindly make it an order of court, my lord, if your lordships feel, my lord, that at least that suggestion has some merit. My lord, whatever sensitive areas, my lord, the police can identify, my lord, in the route. My lord, for those sensitive areas, my lord, they should provide, my lord, barricades. My lord, rather than, my lord, the entire route. My lord, this is, my lord, what I was, for the time being, my lord. Because, my lord, there, my lord.
Yes.
Then, my lord, what we, my lord, had fallen from your lordships and which I had also indicated to your lordships, my lord, in, my lord, my lord, where, my lord, the culmination point of a rally, my lord, is common. My lord, the starting point also has to be common. So that, my lord, people don't, my lord,
But
join.
here, what is the situation? From where,
My lord,
where do they start and where do they end?
My lord, for, my lord, the Hanuman, my lord, Jayanti, my lord, processions, my lord, there are, my lord, going to be, I'm told, my lord, few hundred, my lord, in and around Kolkata. My lord, they have different routes, my lord.
So it will start to the temple and come back to the temple.
Yes, my lord, or, my lord, localities.
Locality.
Also localities. My lord, it's not one temple. And now, my lord, is, my lord, always ending, my lord, on, my lord, by the river or anything, my lord. So, my lord, whatever routing, my lord, is given, my lord, that, my lord, again, I'll come to that, my lord, separately. So, my lord, keeping that in mind, my lord, whatever, my lord, needs to be done in this regard, my lord. So, my lord, we may have, my lord, in, my lord, as an example, my lord, for Kolkata, if I may indicate, my lord, that, my lord, there is, my lord, a rally. My lord, the end point, my lord, in, say, Baliganj area is, my lord, say, let us say the Shiv Mandir. My lord, they're starting out, my lord, at, my lord, from 10 corners. My lord, I would, my lord, request, my lord, that whatever, my lord, the route is, should be one. Similarly, my lord, in, my lord, blocks, my lord, if they have, my lord, one culmination point, they should start, my lord, at a common point. Otherwise, it becomes a problem, my lord.
Yes.
Rather than, my lord, a route starts, and, my lord, we have, my lord, from, my lord, 10, my lord, feeder lanes, my lord, people joining. My lord, if it's in a sensitive area, it could give rise to, my lord, trouble. So, my lord, in this atmosphere, my lord, apropos what has fallen, my lord, then, my lord, the route, my lord, they may ask for, my lord, 7 kilometers, 8 kilometers route, my lord, which, my lord.
No, that you have to restrict.
Yes. So, my lord, that discretion, my lord, should be, my lord, with the police. Then, my lord, route march, my lord, which your lordships indicated. Of course, my lord, the rally is tomorrow. So, my lord, whatever, as many number of route marches that can be done, my lord, by the police, my lord, in these areas, my lord, can, my lord, your lordships, my lord, may, my lord, provide for that. Then, my lord, where there are already 144, my lord, orders in place, my lord, there, my lord, there will not be, my lord, any, my lord, Then, my lord, volunteers, my lord, in all these, your lordships will find, my lord, volunteers of the organization, my lord, names are given with mobile numbers. They, my lord, are supposed to perform, my lord, which has been the case, particularly, my lord, in our major festivals here in the state, which, my lord, have been over 100 years old, my lord, that the volunteers, my lord, assist the maintenance of law and order. So, my lord, this is, my lord, and my lord, it's provided by the organization themselves. And, my lord, even, my lord, in Ram Navami case, my lord, names of volunteers had been given in some cases. My lord, their details should be given and their role, my lord, should be indicated to assist, my lord, the police.
Yes.
Then, my lord, at what is perceived, my lord, by the police, my lord, CCTV to be sensitive areas, my lord, like barricades, there should also be, my lord, CCTV cameras. Other than what is already there. My lord, several roads, my lord, routes already have CCTV cameras. Over and above that, my lord, wherever, my lord, it is, my lord, felt, my lord, sensitive, my lord, they can, my lord, have, my lord, CCTV cameras. My lord, and my lord, the police force, my lord, should, my lord, cover the rally, both at the front and rear end. My lord, that should, my lord, also, my lord, be, my lord, provided. And, my lord, responsibility for damage, my lord, whoever it is, my lord, whether, my lord, if it is found, my lord, that, my lord, any of the members of the procession are responsible for, my lord, any damage, my lord, then, my lord, my lord, naturally, my lord, the provisions, even that order which my learned friend has handed up, 1972 Act, my lord, my lord, provisions, my lord, would, my lord, apply. The last page, my lord.
What is that 1972 Act?
My lord, this is, my lord, Public Order, my lord, Maintenance Act 1972. Earlier, my lord, it only applied, my lord, to, my lord, public property. My lord, but, my lord, there was an amendment introduced in 2017, which, my lord, also made it applicable after the Supreme Court judgment, my lord, damage to private property. My lord, persons responsible, my lord, could also be held liable, my lord, for, my lord, compensation. My lord, so, my lord, and, my lord, the assessment ground situation, my lord, which is also provided here, my lord, page 8. My lord, naturally, my lord, this, my lord, which we, my lord, if, my lord, need is felt, and, my lord, I have spoken.
Because considering this 2000 applications is for Kolkata alone.
No, my lord.
Throughout the state.
Yes, my lord, that is, my lord, what is, my lord, not just Kolkata, my lord. My lord, here I have something to say. My lord, Ram Navami and, my lord, Hanuman Jayanti processions was not a very common, my lord, thing, my lord, in Kolkata, my lord, or, my lord, West Bengal, my lord, which is, my lord, been happening, because these are religious processions. My lord, Durga Puja, yes, Kali Puja, yes, my lord, but, my lord, Ram Navami, my lord, and, my lord, Hanuman Jayanti have not been, my lord, terribly common. Now, my lord, last 5 years, my lord, it has started. Now, my lord, what has now, my lord, happened is, my lord, unknown organizations, my lord, are also, my lord, putting in their applications, because my suggestion to your lordships would have been, whatever religious procession application should come in, my lord, should come in at least 15 days in advance. And, my lord, for the time being, my lord, the proliferation should not be permitted. My lord, whatever was traditional, which has happened over the last 5 years, my lord, those are the ones which are to be considered. My lord,
see, of course, when you introduce this application, it goes without saying that the authority has got power to reject the application.
Yes, correct.
It goes without. But the thing is, the magnitude of the problem or the crowd involved, I don't think so. We don't think that the state police alone will be able to manage it. Because if they are going to go in front and the rear, the mischief happens.
No, they'll be along. No, they'll be along with the procession as well. My lord, deployment.
Volunteers. In fact, I had seen these volunteers in this Durga Puja, etc. They are all young boys and girls who have been given that
badges,
etc. they can't do much. They can't do
No,
much.
no, my lord. I'm not saying, my lord, they'll only assist, my lord, the police. I'm
And
not saying,
obviously, these volunteers have got no power to exercise or detain people, catch them, report them. That is so. It is better that if you requisition at least some paramilitary from the neighboring state or somewhere, so that they can assist. Not taking that there is a failure on the part of the state missionary. No, it is to assist the state missionary. And as you said, this 5 years, lot of these things have erupted. I mean, coming up very recently, Western influence, etc. Those things are there. And these are, once it has come to stay, it has come to stay. But how to reassure the public that don't worry, nothing will happen. I am here.
my lord, one is, my lord, I think, my lord, to start with.
And a learned friend was saying that they are dropping stones from the terrace. And can we put a net right through?
Not even before the elections, we have paramilitary forces patrolling the areas. This is only to give an installation of faith and confidence on the people.
Because if something, some person may miss, the other person will be able to detect. And they can keep patrolling the entire area, any shady movement. And the intelligence wing should work. That's very, very important. If there is an allegation that the incidents action which precipitated the incidents were pre-planned and we were not able to find, then there is a failure of intelligence. Yes, yes, you're audible. You stay there.
That is something which has to be fixed. I joined the issue general of the state to say that it's a new type of festival which is coming and which has some unique features, unlike the which are other festivals. Please have there are also successful these can manage. These processions are not taken to the Ganges or to the temple or something. The problem with these processions and others are here reaching the political leaders.
All right, we'll see what best can be done. Yes, madam, what do you like to say?
There are three issues on which I am before your lordships today. The first and the foremost issue is, your lordship, that even after whatever arson and violence took place, we have seen that the Honorable Chief Minister of a state who should be unbiased has on number of occasions made such utterances which is totally against one community. Now, your lordship, I am very neutral. I am not speaking in favor of a community or against a community. I am just questioning this as a normal person, a resident of West Bengal. Can a chief minister have such biased statements against one community where she's saying, your lordship kindly hears me out, and I have videos and everything which I can present before your lordships, where she's saying that it is the month of Muharram. Muslims can't do anything bad. It is upon you, Hindu, to ensure that they stay safe. It is upon you, Hindu, to make sure and protect them. What does this mean? That you have divided West Bengal in between two communities, which is Hindu on one side and the other is Muslim. Such biased statements coming from a chief minister of a state, and that on public platform in a rally in Khejuri, Midnapur, which resulted, your lordship, into further violence. Now, here's a report. I was not a part of the petition. I have filed a petition today, and I come to know that your lordships had sought for a report which the state has filed today. But they fail to say this, that even after your lordship's order, there was violence in Rishra. On the railway station, a train was attacked. Stones were pelted. Bombs were hurled in presence of police. And there was a standstill for 4 hours. Now my honorable senior rear says that police will take care. Police was present in part of the rally in Shivpur. Now I say so, not as hearsay. Your lordship, I was a part of that rally. I was brutally attacked on my eyes. I had to get operated. That is why I was wearing glasses in the morning. Police was present there as a mute spectator, just next to me. Stones were being hurled and the police did nothing. This police, Your Lordship, and I'm telling so, for 2 hours, they had no instruction to even lathi charge. I am not saying anything against any community, but their demeanor proved who they were. Now here, my second point, which I will not take much time of Your Lordship, I am keeping it very small. The second point is, here in a report, they say 40 people arrested, 45 people arrested. In the videos, we could all see in which area this took place. Today, my senior says that we will restrict the areas. Now, Your Lordship, he also mentioned that Ram Navami and Hanuman Jayanti are recent fashion. Can we say so? Regarding one particular community on their belief, can we question it? If it is a fashion, all the people are on the streets on Ram Navami. Can we stop them? Can we do the same for some other community? If the rules are being made today, my humble submission is, we all want peace. If such rules and restrictions are being made today, can my seniors say that the same will be applicable on any other occasion or processions of Muharram or Eid?
Obviously. Nobody has got a right. No? You can't. You are entitled for free movement.
I agree with your lordship.
And if that is going to be hampered, definitely the state can put restrictions.
Can.
This rally or procession from the format given doesn't say about any function. It goes without saying it applies
I
to
am
all
a
rallies.
peace-loving and abiding citizen, Your Lordship. I agree to this completely. But when again I come back to my first point, where a chief minister has questioned one particular community, is it possible? She has already put them in a witness box.
You have already said. We will see what.
Your Lordships, a random arrest is being made, and I tell Your Lordships, so this is the first time that I'm appearing before Your Lordships. On number of occasions, I have raised my voice for the people, for causes which are for the people. If Your Lordships have heard about the post-poll violence which happened in Bengal, I was the first petitioner in person. I ensured that people all over Bengal could go back to their houses by reaching each and every police station on my own. I have ensured so. So it is not that I am here doing any kind of a drama before Your Lordship. I am a peace-abiding and
Nobody has alleged that you are creating a drama.
number of occasions this allegations has come from the other side. So, Your Lordships, I am also saying this, that after all this has happened, number of arrests are being made randomly, where the people who were part of peacefully in this procession, they are also being picked up from the houses. And those who did not even participate are also being picked up from the houses. And those, and I mention here, Hindi speaking, those who are Hindi speaking and having some allegiance to some political party who's in opposition, they are being arrested. Now, who will question whether they were present there or not? They are being brutally beaten up in the police station. They are being brutally beaten up. They are showing a video which is viral with a boy having a pistol in his hand. Has the police mentioned for once that there was any firing in that occasion from that pistol? No. But they have brought them in a witness box that these people who are part of the processions, they were with guns on streets and they have created all this hooliganism. Why not those who did not want these processions and continuously are saying, see, we have given you permission. See, we have given you permission. So there is a huge political scandal which is behind this. And Your Lordships, my humble and last prayer before Your Lordship is, we have seen in post-poll violence, number of times, the court had held that the police is incapable of performing. I am not saying so, but I am saying in order to ensure that the police performs well and to bring back the confidence of the people who will be out tomorrow on the streets saying Jai Hanuman Ji ki, there should be certain force deployment. This is all I have to submit before Your Lordship.
Thank you.
Statements actually caused this. She has been a party to this. So
Reference may be made. Order dated 3rd of April 2023, which reads as follows. The AG is not filed any report. No, AG filed any report. Advocate General, that report is available? No.
The reports of Millard.
No, as per the order.
Yes, Millard. We had Millard.
In terms of the directions in the above order, a report has been filed by the
দুজনের দুটো সেট যেরকম অর্ডারে দিয়েছি সেরকম দিন আমার দিন এদিকে একটা দিন একটা দিন আপনি ওটা দিন না
report filed on behalf of the Commissioner of Police, Howrah Police Commissionerate. A report on behalf of the CID regarding Shibpur Police Station case number 113/23. Report on behalf of the Superintendent of Police, Islampur Police Station, and report on behalf of the Commissioner of Police, Chandanagar Police Commissionerate. The reports appear to be elaborate along with the annexures which are taken on record, and the contents of the report will be examined on the next hearing date. The issue which has been brought to our notice by the learned advocates appearing for the writ petitioners, as well as the learned advocates who are granted leave to make submission before this court. After hearing the submissions of the learned advocate general, the additional solicitor general, and the learned counsel appearing for the National Investigation Agency, we are of the view that certain directions are required to be issued so as to ensure that the Hanuman Jayanti to be celebrated on tomorrow, on 6th April 2023, is celebrated in a peaceful manner without any untoward incidents. The learned advocate general has produced before us a copy of the application which the organizer, which the concerned organizing body has to submit before the police authorities for granting no objection certificate for conducting the meeting or rally or procession. Joint Commissioner of Police, Headquarters, Calcutta. The said form contains 27 conditions which were perused by us. We find that the conditions should be more stringent, and it appears that the form is a common form for all processions, rallies, and meetings. And considering the fact that during the Ram Navami festival, several incidents had occurred in the districts neighboring Kolkata, we are of the view that a more stringent conditions are required to be imposed. First and foremost of the same is accountability. The persons organizing the rally or procession should be made accountable, and requisite amendments be made in the form. The police authorities are at liberty to restrict the number of participants in the procession so that the procession is performed with religious flavor, without any political affiliations. The police shall ensure that in vantage points, barricades are erected, and preferably a common route can be suggested, can be prescribed for the procession to proceed, so that the police authorities will be able to control the crowd and prevent any untoward incident. The police shall also have the discretion to restrict the route. Considering the past events which have taken place, which are very unpleasant, the police authorities are directed to conduct a route march today, within bracket 5-4, to reassure the public that the police are there to safeguard their interest. In areas where orders under section 144 of the Act of CRPC have been promulgated, no rally or procession should be conducted. It is stated by the Learned Advocate General that the organizations which have applied for permission to conduct the procession also would furnish the names of their volunteers. In our considered view, the volunteers, though may assist the police, but will not be in a position to control any untoward incident. So the role of the volunteers should be made minimal, and the full details of all the volunteers should be collected by the police, and they should be given identity cards. Additional CCTV cameras shall be installed apart from videographing the vantage areas through which the processions will be taken through. It is stated by the Learned Advocate General that as of now, more than 2,000 applications have been received. As of now, in two of the areas in the neighboring districts, orders under section 144 CRPC have been promulgated. And we are informed that a large police force has been deployed in those areas to maintain law and order. Therefore, considering the largeness of the issue and in order to avoid any breach of peace, we are of the considered view, we are of the definite view that the state government should requisition the assistance of a paramilitary force from the central government. In fact, this was the observation. This was more or less the observation made by the Honorable Division Bench of this court in the case of in WPAP 258 of 2022, dated 15th June 2022. The assistance of the paramilitary force will definitely help the state police in maintaining law and order, apart from assuring the general public that their safety and security will be taken care. That apart, the state will also be at liberty to take appropriate action under the provisions of the West Bengal Maintenance of Public Order Amendment Act 2070. The West Bengal Maintenance of Public Order Act 1972, as amended by the West Bengal Maintenance of Public Order Amendment Act 2017, wherever it is necessary. The purpose and scope of this order and direction is to ensure that the public are assured and reassured that they can be safe in their homes and they will not be affected by the riotous behavior of miscreants. The registry has received a representation from an additional district and session judge, Diamond Harbour, South 24 Parganas district. The learned district judge has lamented, learned additional district judge has lamented that he is unable to, he was unable to even get requisite police assistance, police assistance for his family and himself, whose residence is situated in Rishra. This aspect has also to be taken into consideration, and it should be ensured that in all these districts which have been perceived to be sensitive areas, the judges of the district judiciary should be in a position to freely discharge their judicial functions. And if there is any request made by the district judiciary for adequate police help or protection to enable them to function peacefully, the same shall be provided by the state without putting any fetters. It goes without saying that if any of the local public also apprehend any breach of peace in their locality, and if the same is brought to the notice of the police authorities, they shall immediately act on such request and ensure that no untoward incident occurs in their area. Thus, the underlying principle, thus what is to be highlighted is that prevention is better than cure. Therefore, the state police are required to take all steps with the assistance of the paramilitary force or any other central force to prevent any untoward incidents, so that the public are not put to jeopardy. The above directions shall be scrupulously complied with. Before that, you say. The learned advocate appearing for one of the writ petitioners submitted that in which area it happened? In Rishra, where the rioting took place, stones were pelted from the Shipur. Stones were pelted from rooftops of the building. Had the intelligence wing of the police department been little more vigilant, such pre-planned attacks could have easily been averted. Therefore, the intelligence wing of the state police shall be strengthened, and all steps be taken to avert any such pre-planned attacks or violence which may be planned. The above directions shall be scrupulously followed, and an action taken report be submitted on the next hearing.
Your Lordships, if just one observation can be made that...
Yes, wait. We forgot, I don't know. Considering the sensitivity of the problem, this court directs that no person, either a political personality or a leader or a common man, shall make any statement in public or to the media concerning the festival to be celebrated tomorrow.
They should desist from making such utterances, Your Lordship. Because they're in such responsible position.
May I make one? May I make one? My lords have been pleased to direct the state to seek the assistance of the parliamentary forces. My lords are aware that under the 7th schedule, the law which is made by the parliament in respect of BSF, of the CISF, of the CRPF is an independent power. So they may be allowed to have a route march independently, irrespective of the facts.
That you sort it out, sir. That you sort it.
Secondly, the report which has been filed.
But time is too short now. They will make a requisition, you deploy the force.
Secondly, the report which has been filed.
We have yet to go through this.
No, sir. I have been instructed to say that the Home Ministry has already directed the Chief Secretary to submit a report. This has to be whether in consistence with this report, the Home Ministry's direction, which they have submitted the report.
As we have directed, the state to make a request for deployment of paramilitary forces, the central government, the concerned authority of the central government shall take expeditious steps in deploying such forces, since the festival is to be celebrated on tomorrow, that is 6/4/2020.
And we shall file a response to the report. That party will be given.
We are ready to go through, sir. First, let something happen peacefully. Tomorrow we will come back.
My lord, may I?
Everything is there. We just adjourn the matter.
My lord.
Your Lordship, just one last submission.
I-
Kindly
that's-
go through the report, the way they are arresting people. That is very, very important, Your Lordship. Very important.
My lord,
Great.
Can you just slightly remove the mask and speak?
My lord,
Use the microphone, please.
My lord, our writ petition already filed, my lord, on a similar pair, my lord, maybe tagged, my lord, only.
You are not here at 12 o'clock. We asked you to be here at 12 o'clock. Your learned friend also said she wants a writ petition, she wants to intervene. Nothing. You could have, we have heard everybody, passed an order. You come on the next hearing date. We are going to be here, you are going to be.
My lord, returnable debt may be mentioned. Returnable debt may be mentioned.
Yeah. Pardon, sir?
Returnable debt of this case.
Or whenever you want it.
That is mentioned.
No, that is, we will definitely mention. All
Lordship,
cases.
the
will have
courts are
written.
not in session tomorrow, and thereafter is a holiday for Good Friday. So if on Monday, if there is any untold incidents, if the
List
matter
on
can
10th
be-
April.
Grateful, Lordship.
And you, all of you give your names.
Your Lordships, give it.
So that
Your Lordships, our petitions have already been filed, but since Your Lordships were not
No, we have
inclined
heard you,
towards
we have
staying,
heard you.
grateful, Lordship.
You collect all the names. Huh?
So item number 55 will not be called.
So it will be tagged. Don't. As soon as they type it, we'll correct and even we'll come half an hour late. We'll correct and ensure it's approved. What is the time? Sir, you can go and type and somebody else can come. Yes, AG.
My lord, only one thing, my lord. Once the requisition is given, my lord, the deployment, etc., will be
Immediately, yes.
yes. And my lord, wherever, my lord, the state, my lord, authorities want them deployed, my lord, that should be, my lord.
That they will discuss.
Yes.
Both the command.
We have the office of the Inspector General of CRPF, RPSCIS.
They will coordinate. They are all very.
West Bengal also.
They will coordinate. They will coordinate.
From the other states.
You have to ask another AR court to come. Then only we can. No, seriously, we come to item 10. Yes.
Grateful, man.
Appellate side Delhi list, serial number 10.
Yes, madam.
Lord, I appear for the appellant in item number 10. Lord, this is an appeal from an order passed by the
Late by Mr. Nag.
Honorable Writ Court, my lord, dismissing my prayer for compensation. Lord, I intend to move the appeal today, my lord, but the difficulty is I have to take some instructions from the client, my lord. If your lordship wants, I can proceed with the matter, but my lord, there are some material instructions which I need to
What
take.
is the tortious claim? Is it compensation for what?
Compensation, my lord, regarding the illegal disconnection of the electricity. It has been confirmed in 3 stages. That is the RGRO, the Ombudsman, as well as the Writ Court. My lord, all the 3 forums have held that the disconnection of my electricity was not in accordance with law. The petitioners are septuagenarian people, my lord. They're aged 70 years and plus. They were made to run from pillar to post for a continuous period of 4 years. And thereafter the reconnection was given. And my lord, the claim today as on date is, my lord, refusal on account of the Ombudsman, because my lord, Ombudsman refused my claim for compensation. Thereafter, I preferred a writ. Writ Court, my lord, also denied my claim for compensation.
On what ground it was rejected?
My lord, the Writ Court has held that, my lord, that I have approached the court. My lord, it's a very arguable fact. The point of law that the Writ Court and the Ombudsman has held that the due date to claim compensation is on the date when the claim crystallizes. This was my stand. But my lord, the stand of the learned Writ Court was the date to claim compensation was the date on which the reconnection, the disconnection happened. That was 4 years ago. My lord, now the not just one.
No. Reconnection was granted based on court orders.
Reconnection was granted based on the ombudsman's order, not on the court's order.
So your
reconnection was already given before I approached the writ court.
But your claim for compensation will arise only from that date.
From the date of reconnection. My lord, what the learned writ the honorable writ court has held, my lord, that the claim for compensation arises when the date of disconnection happened. So, my lord, this is the point of law which I want to state, my lord. And my lord, it's a very technical thing, my lord. And what the learned writ court has done, my lord, it has passed 2 orders on in a different matter, obviously. In a different writ petition, the learned writ court has held the correct proposition which your lordship had just stated it to me, that the date to claim compensation will arise from the date.
But the writ court has referred to some clause 15.
Clause 15.0, my lord. My lord, I believe that particular notification.
You get some.
That particular notification is not with you, my lord. I believe. So, my lord, I need to make copies.
I have annexed that copy. In my affidavit in opposition, I have annexed, my lord.
No,
I just need to take, my lord, some material instructions, my lord.
That's a different issue. But I have also annexed. I have supplied a copy.
All right. He wants some time accommodation. We'll accommodate.
But only one point I want to clarify, lordship, that disconnection 14, restoration in 18. And he approached, thereafter. Therefore, court held when 90 days is the bar from the date of disconnection, because your right to have compensation arises, there you have to approach within 90 days. If you do not do that, the law bars him from making any claim for compensation.
But
I shall satisfy, my lord, that we have approached.
Reconnection took place only after 4 years.
After reconnection, because he has complied the payment. Therefore, non-payment of dues was done.
That non-payment issue was adjudicated. Ultimately, the ombudsman held in his favor.
No.
Yes, my lord. The ombudsman held in my favor. The writ court also held in my favor.
Compensation part was rejected by RGRO.
We are not on compensation part.
Disconnection.
We are on the disconnection part. 14 disconnection, reconnection in 18.
18, yes, my lord.
Based on the orders of ombudsman.
Yes, my lord.
Subject to payment. He complied the order by making payment. Then restoration was done by RGRO, not by ombudsman.
When my learned friend is telling on the merits, I shall also address on the merits.
The learned advocate for the appellant, adjourned. Whatever date you want, you take.
My lord, any date, my lord. Your lord.
You tell the date, sir.
My lord, next week, my lord.
All right, next week you give a date. Next.
Serial number 11. Let it in the May because he is not willing today. Let it.
No. Not in the May, my lord. No, my lord. I will do it on the next day.
I may not be.
If you are not willing to argue on that day, we will see.
Grateful, Lord.
You leave that to the discretion of the court, sir. You don't say. Then from tomorrow onwards, all matters will go to June monthly list.
I'm much obliged, my lord. Much obliged. Grateful.
For that is
Please.
No. Not for that.
What is this matter?
But I beg to appear for the respondent writ petitioner. This is my maiden appearance before the Honorable Acting Chief Justice. But how I oppose? Appellant is not here.
Probably he thought it won't reach.
No, that
yes,
was going on. It's okay. Asun sir.
No problem.
Milord, the appeal has to be heard out. Milord, all papers are here.
Okay. We'll fix a date.
Paperbook has to be prepared.
Any date, Milord, Lordship gives me, Milord. Any date.
But how much time you'll take for the paper book to be made ready?
2 weeks. Only 2 weeks, Milord. Milord, return of bank guarantee in a writ petition. Very short point. Whether it can be done.
The learned advocates appearing on either side submitted that the appeal has to be heard. They let the paper book be made ready and filed within a period of 2 weeks. This is the matter in the monthly list of May.
Monthly list of May, or it will be better, my lord, if it just after summer vacation.
Lordship will keep it in May, Milord. No difficulty, Milord.
Yeah, May we'll have only 2 weeks.
Yes, that's why
any date Lordship gives me because it will not take much time.
June. Next.
Serial number 12.
We have to be very cautious now appearing before the court.
Why?
My lord, we have been shown, my lord.
No. You will become, you are known all India.
No, that is, my lord, a prohibition in the Advocates Act. You cannot advertise yourself.
No, this is not
advertising. I am sometimes also appearing in a court that has been seen by the.
He is always there, Milord. He is known all.
This is really an open court.
My lord, I don't know, my lord. Because we are not accustomed, so that's something new.
That is always there, my lord. He is known all India.
Abar.
Without YouTube. Read.
Yes.
Lord, I beg to appear on behalf of the appellant applicant, my lord, led by Mr. Shayan Sinha. Lord, due to some personal difficulties, he is not in a position to come to
He's
court.
not able to come.
I'm praying for not this.
Freezing of bank account.
Yes, my lord.
And writ petition was filed for that. But how writ is maintainable?
My lord, my senior will apprise my lord with.
My lord, kindly have a look at page 2 of the impugned order, my lord. Last paragraph. Indeed, on the question of alternate remedy, there is serious doubt as to whether court can at all entertain writ petition, as to whether herein can get benefit, that is a result of a pending, so cannot without calling for a.
And now who has passed the order freezing the bank account?
My lord, Mr.
CBI. No.
No.
CID, my lord.
But I'll tell you, Lordship, my lord, what happened, my lord. My lord, here, my lord, the CID, my lord, was conducting an investigation, which, my lord, as per, my lord, in another public interest litigation, my lord, in WPAP 493 of 2022, which is pending adjudication before your lordships, my lord. My lord, here, my lord, the allegation was, my lord, that a parallel investigation is being conducted by the CID in respect of the cattle scam cases, which is being already conducted by the CBI. Now, on that score, my lord, there was an interim order, my lord, which was passed. If my lord kindly takes pain to come to page 117 of the stay application, but the order has been annexed. And if my lord kindly takes, my lord, internal page 4 of the order at page 120, I'll just place the relevant portion, states that we have heard the learned counsel for the parties, and on perusal of the record, we are of the opinion that till the respective stand of the parties comes on record in the form of affidavit, it would not be proper to permit the state investigating agency to enter into the field in which the central investigating agency is already investigating. Hence, we direct that the state investigating agency, on the plea of investigating the offences relating to RC case number 19 of 2020, will not enter into the subject matter and connected field of investigation being conducted by the CBI in FIR being RC case number such and such, and will ensure unhampered investigation by the CBI. Now, this particular case, my lord, affidavits have been exchanged, my lord. We, my lord, on behalf of the CBI, my lord, we have already disclosed our stand, my lord, that we are ready and willing to take over these particular investigations, because according to us, my lord, this hits directly, my lord, on the investigation, my lord, that is being conducted by the CBI.
Now,
my lord, at the interact, my lord, what happened, my lord, there was freezing, my lord, of the bank account by the CID, and my lord, this the appellants here, my lord, they came up by way of filing a writ application. Now, it was, my lord, the interim order was refused. Thereafter, my lord, they went up in appeal. My lord, kindly take pain, my lord, to take the first order, my lord, passed in appeal, my lord, during the vacation by the division bench presided over by the Honorable Justice Joymallo Bagchi. So his lordship was of the opinion, or it is there in your lordship's file, my lord, the order. I'll just give the date of the order. It's 13th of October, my lord, 2022. But I'll just place the order. It's not a very longish order.
Yes.
Mr. Dotto, learned senior counsel, submits that the impugned directions for freezing of bank accounts of the appellant is contrary to the order passed by a bench presided over by the Honorable Chief Justice in WPAP 22498 of 2022, the order that I last referred to. We find that the freezing orders were passed by the investigating agency on September 12, 2022, whereas the order restraining the investigation process was passed on 27 September 2022. As the freezing orders had preceded the stay on investigation, no order be passed at present. Let the matter appear before the regular bench immediately after the puja vacation. Now, thereafter, my lord, the matter was taken up on a number of occasions. It has been adjourned, my lord, in view of the fact, my lord, that the main matter, my lord, the public interest litigation wherein this particular interim order was passed, my lord, that is pending, my lord.
But the larger issue is, the writ is maintainable against this order. Against the freezing of a bank account.
Yes, my lord.
The investigation is going on. Who has to investigate? That's a different dispute. Let whether the CID has to do it or CBI has to do it. That's a different matter. Some orders have been passed. But how a writ is maintainable?
My lord, kindly makes it not today, my lord. Mr. Shomo Majumdar is appearing in this matter, my lord. He's engaged in some other court.
Sharon Sinha bol rahe
So we don't. But till date, CBI is not taken over the investigation.
But that is one of the subject that is to be decided in the public interest litigation. The public interest litigation is running in your lordship's list. It is appearing as item number 559 in the monthly list of your lordship.
So till now, CBI is not taken over. So therefore, CID's freezing will continue.
We have filed a CAN application in that regard, my lord, for defreezing the bank accounts.
In terms of instructions given by the CID restriction, we have freeze the account of.
Let the account be frozen. You don't do anything.
My lord, my CAN application is pending in that regard, my lord.
Please.
May I just suggest this, my lord? May this be taken up, my lord, after a decision, my lord, in that particular matter, in the parent matter. That is the parent matter. That will decide everything. And our stand is there, my lord.
He is handicapped. His senior is not there.
Yes, my lord. My CAN application is in that regard only, for defreezing the bank accounts.
All right, not today.
Wait for me.
Can to copy that.
Can where copy is sir?
Yes.
But I'm privileged to have my maiden appearance before my lord acting Honorable Chief Justice. But I take the opportunity to address on behalf of the private respondents. There was a previous order, my lord, this appeal is barred by limitation. And your lordship will be pleased to see the explanations.
My appeal.
No, I only just indicate this is my duty.
My appeal, let me make my submission, my lord. I led by Mr. Datta today, he is not here. Anyway, my lord, I am making submission. But this section 5 application, 107 days delay. The portal is a sensitive issue. The matter was placed before various. You are opposing the delay.
107 days. Because
107 days. Only,
the level and the number of delays could not be fatal at any point of time. There is a plethora of judgments. It is the explanation. Even a one-day explanations could be well made. Even 1,000 days explanation could not.
Right.
The explanation that is given is a red tapeism theory. Red tapeism theory. Because it is a government institution, so various tables are to be covered. Various decisions are to be taken, various approval. And starting from 2012, in the report of the Postmaster General, including 2020, the Honorable Supreme Court had deprecated if this theory be applied, then no mercy, no condemnation of delay. That is my point, my lord. I am covered with 3 judgments of the Honorable Supreme Court. Your lordships are well aware of the fact. And that is my only point. I do not say whether it is 107 or 1 day or 1,007 days delay. And that is the point if your lordship kindly takes up. My lord, the delay petition, section 5. My lord, other than this ground, my lord, nothing has been said. So kindly comes to paragraph 13. I'm extremely sorry, my lord. This is, my lord, something your lordship will be pleased to find from paragraph 20.
No, starting from paragraph 13.
Very well, my lord. My learned friend from the other side, my lord, wants to show you lordship from paragraph 13. Lordship, kindly have a look from paragraph 13.
Yes.
The para 23 is the moot.
Yes.
That may be considered. The petitioner humbly submit that the petitioner is a statutory body constituted under the provisions of Major Port Trust Authorities Act 2021. It's something wrong, but anyway, it's statutory. Is under control of the central government. Any decision to file any appeal has to be routed through different offices of the petitioner, and the file has to be placed before the various authorities for the approval. So this is the ground. It cannot sustain.
And you give those, one of those decisions,
Lord.
latest decision.
Lordship, latest one. 2020. See, judgment again, 2020, volume 10, Supreme Court. Case.
Each and every day I have explained, each and every day.
But it is not a matter of explanation, it is a matter of giving Millard.
All right, we'll consider.
Lordship. Millard, this is 2020, volume 10,
Yes.
Supreme Court cases, page 654. Millard,
2020.
it follows from the Postmaster General decision
2020.
Millard reported in 2012, volume 3, Supreme Court cases, page 563. Millard may kindly comes to Millard, the background of the case at paragraph 3. Here the Supreme Court said, Millard, there is no difference between a crown and its people.
Correct.
If the law is one for the people, then it's similar for the crown. Merely because I am a government institution, Millard, I cannot get any favoritism, and that cannot be a ground for delay. This red tapeism theory, Millard, has been deprecated, Millard, in a stringent manner, Millard, by the Honorable Supreme Court in 2020, volume 10, Supreme Court, page 654, para 3. No doubt, some leeway is given to the government in efficiencies. But the said part is that the authorities keep on relying on judicial pronouncement for a period of time when technology had not advanced and a greater leeway was given to the government. Quote unquote, Lau versus Katiji. The position is more than elucidated by the judgment of this court in Postmaster General that I have now just referred, where Millard para 27 and para 28 was quoted. It is not in dispute that the persons concerned were well aware or conversant with the issues involved, including the prescribed period of limitation for taking up the matter by way of filing a special petition in this court. They cannot claim that they have a separate period of limitation when the department was possessed with competent person familiar with the court proceedings. In the absence of plausible and acceptable explanation, we are posing a question why the delay is to be condoned mechanically, merely because the government or a wing of the government is a party before us. Now, Lordship, kindly, I do not need to trouble your Lordship to go through para 28 and 29. It is just nothing but to follow up. Now, kindly comes to para 30 in the same Postmaster General decision. Considering the fact there was no proper explanation offered by the department for the delay, except mentioning of various dates, according to us, the department has miserably failed to give any acceptable and cogent reason sufficient to condone such a huge delay. Now, 8 years hence, the said judgment is still unheeded. Para 3, the last sentence. Para 4, a reading of the aforesaid application shows that the reasons for such an inordinate delay is stated to be only due to unavailability of the documents and the persons of arranging the documents. In para 4, a reference has been made to, quote unquote, bureaucrat process works. It is inadvertent that the delay occurred. The same thing. Same, nothing more, no, better explanations. Para 5. A preposterous proposition is sought to be propounded that if there is some merit in the case, the period of delay is to be given a go by. If a case is too good on merits, it will succeed in any case. It is really a bar of limitation which can even shut out good cases. So, the Supreme Court has also considered that merely because of the ground, what previously the High Courts and the Honorable Supreme Court considered that merely because they had some merit, but so the delay petition will be ignored. That cannot be. This does not, of course, take away the jurisdiction of the court in appropriate cases. Now, this is an appropriate case. In a similar fashion, they say this from rounding the table, we had to take a time and because of we are government. 6, we are also of the view that the aforesaid approach is being adopted by what we have categorized earlier as quote unquote certificate cases. The object appears. Now, kindly skip over 6-7 lines. From the last 7 lines from right hand side. The irony is that in none of the cases, any action is taken against the officer who sit on the files and do nothing. Have you, Lordship, got my lord? It is presumed that this court will condone the delay, and even in making submission, straightway the counsel appear to address on merits without referring even to as the aspect of limitation, as happened in this case, till we pointed out to the counsel that he must first address us on the question of limitation. And ultimately, my lord, in paragraph 8, next page, looking to the period of delay and casual manner in which the application has been awarded, we consider appropriate to impose cost such and such, to be imposed such and such. And Ultimately, the special leave petition was dismissed even on the ground of limitation. Now, my lord, the next judgment, which immediately passed, my lord, after this, was reported in 2020, volume 10, Supreme Court cases, page 657. The previous report was on October 15, 2020. This report was on October 27, 2020. Precisely followed, my lord, this judgment.
2012 3 SCC কত ছিল রে পেজ 2012 3 SCC
Millard kindly comes to paragraph 1. You'll also maybe consider the facts. The state of Madhya Pradesh continues to do the same thing again and again, and the conduct seems to be incorrigible. The special leave petition has been passed such and such. Now, para 3. We consider it appropriate to direct the Chief Secretary of the state of Madhya Pradesh to look into the aspect of revamping the legal department, as it appears that the department is unable to file appeals within any reasonable period of time, much less within the limitation. These kind of excuses, as already recorded in the aforesaid order, are no more admissible in view of the judgment reported in Postmaster General. Now, this Postmaster General was relied in 2020, the previous judgment, also following the later judgment. I'm sorry, ma'am. We have expressed our concern that these kinds of cases are only certificate cases, such and such. Now, next, also the looking in the period of delay and the casual manner in which the application has been worded, the wasted judicial time. So, my lord, if your lordship, my lord, looks into from paragraph 13 onwards, my lord, the question of giving any explanation and how, my lord, these explanations are, my lord, afforded, the ultimate cause that's being shown to your lordship, this is since we are a government concern, so we must take some leave away from the court, and it can be construed as an admission and for all times, my lord, admitted to be considered that since we being offered our application on behalf of the government, whatever be the limitation, it has to be condoned. These cannot be, my lord, there is no more better explanation, and by way of a reply, it is a settled law, my lord, they cannot improve what they have stated in their application. And other than para 23, if a lordship see, my lord,
the governments are from para 12.
12.
We went through it.
And the main point is that para 23.
We have heard the learned advocates for the parties. There is a delay of 107 days in filing the appeal. In the affidavit filed in support of the condoned delay application, it has been stated that the order impugned was passed by the single bench on 22nd August 2022, and thereafter the advocate for the petitioner communicated the order to the chief law officer of the appellant by email date on the very same day, that is 22/8/2022. After obtaining the server copy of the order, the advocate for the appellant forwarded the same to the concerned officer of the first appellant by email dated 25/8/2022. Thereafter, by email dated 6/9/2022, the concerned department sought advice of the chief law officer on the aspect as to whether appeal has to be preferred against the order passed in the writ petition. More particularly, certain other observations made in the said order. Thereafter, the chief law officer by email dated 6/9/2022 at about 4:44 p.m. requested the learned advocate for a early discussion in the matter. The advocate fixed a conference in the matter on 28/9/2022. In the meantime, the advocate applied for the certified copy of the order on 15/9/2022. The concerned officers of the appellant held a conference with the advocate, learned advocate, on 28/9/2022. Thereafter, the court was closed for puja vacation from 1/10/2022 to 30/10/2022. It is stated that the advocate for the appellant was out of station during vacation, and during the vacation, the appellant by email dated 18/10/2022 instructed the learned advocate to prepare an appeal against the order passed in the writ petition. The advocate drafted the appeal and the stay application on 2/11/2022. Thereafter, instruction was given to engage a senior counsel to settle the draft, and the senior counsel fixed a conference on 12/11/2022 and thereafter the concerned department supplied all the documents on 16/11/2022, and the draft was settled by the senior counsel on 21/11/2022. The said draft memorandum of appeal and the stay application was forwarded on 21/11/22 for its approval of the concerned department. Thereafter, the learned advocate for the appellant received the draft memo of appeal and stay application duly approved by the concerned department of the first appellant on or about 12/12/2022, and after the draft was approved by the learned advocate, the appeal was filed on 13/12/2022. In this process, the appellant would contend that 107 days of delay has occurred, which was beyond the control of the appellant. Further, it is submitted that the appellant is a statutory body constituted under the provisions of the Major Port Authorities Act 2021 and is under the control of the central government. And any decision to file an appeal has to be routed through different officers of the appellant, and the file has to be placed before various authorities for their approval. Therefore, it is contended that the delay is unintentional and caused on account of certain factors which are beyond the control of the appellant. With the above submission, the learned advocate appearing for the appellant sought for condemnation of the delay. The learned advocate appearing for the respondent writ petitioner vehemently opposed.
I am not the writ petitioner, I am the respondent, private respondent.
Appellants, the respondent, who was a private respondent in the writ petition, vehemently opposed the prayer for condemnation of the delay, contending that all the averments set out in the affidavit are clearly show red tapeism and bureaucratic approach, and merely because the appellant is a statutory body under the control of central government, the law of limitation cannot be relaxed for the appellant. In support of his contention, reliance was placed on the decision of the Honorable Supreme Court in State of Madhya Pradesh and others versus Berulal, 2020 10 SEC 654, and State of Madhya Pradesh and another versus Chaitram Mewad, 2020 10 SEC 667. After we have elaborately heard the learned advocates for the parties and carefully perused the materials on record, we need to point out that the law on the subject has been well settled. In the recent decision in the case of the Honorable Supreme Court in Berulal, the earlier decision on the points on the issue, namely the decision of the Honorable Supreme Court in LAO versus Kajji, 1987 2 SEC 107, and the decision in Postmaster General versus Living Media India Limited, 2012 3 SEC 563 were referred to. And it was pointed out and considering the averments pleaded by the state of Madhya Pradesh before the Honorable Supreme Court, stating that the delay was due to unavailability of documents and the process of arranging the documents was held to be a preposterous proposition, and the court and the court made very strong observations against the manner in which the officers were sitting on the files and doing nothing. And ultimately, the special petition was dismissed by imposing cost. They said the decision in Berulal was referred to in Chaitra Mahadwe, and the court adopted a similar, and the Honorable Supreme Court adopted a similar approach and dismissed the appeal, imposing cost of rupees, imposing cost. It is a settled legal principle that the law of limitation has been enacted not with an intention to defeat the rights of parties, and courts have always taken note of the distinction where by taken note of the conduct of the parties as to while conduct of the parties while considering whether a delay has to be condoned or not. The Honorable Supreme Court in the case of Berulal was considering a case where the delay was 663 days in an appeal filed by the state of Maharashtra. The reasons given in by the appellant therein was examined, and all that they had stated was the documents were unavailable and the documents were to be arranged. Similar was the stand taken by the state of Madhya Pradesh in Chaitram Mewadi, where the delay was 588 days. Under normal circumstances, none stands to benefit by lodging an appeal belatedly. There may be cases where, on account of certain malafide reasons, the appeals are lodged belatedly, and those cases have to be dealt with firmly, and no indulgence has to be shown in such cases. In the case on hand, there is a delay of 107 days in filing the appeal. In the preceding paragraphs, we have set out the reasons given by the appellant for not able to prefer the appeal within the period of limitation. On going through the reasons, we find that the reasons cannot be wholly brushed aside as being a clear as being only a bureaucratic process. In fact, from the relevant dates and events, it is seen that the appellant has been earnestly following up the matter, and ultimately the appeal was lodged. In Berulal, the Honorable Supreme Court, in paragraph 5 of the order, has pointed out that it is really a bar of limitation which can even shut out good cases. And this does not, of course, take away the jurisdiction of the court in an appropriate case to condone the delay. Therefore, we are required to examine as to whether the case on hand was an appropriate case. On going through the facts and circumstances pleaded by the appellant, we find this to be an appropriate case, and we do not find, and in the absence of any malefides alleged against the appellant for lodging the appeal with a delay of 107 days, we are of the view that discretion has to be exercised in this case and the delay in filing has to be condoned. Accordingly, the application in Can 2 of 2022 is allowed and the delay in filing the appeal is condoned. Thank you.
My lord, my another application is there, my lord.
For what?
For stay and injunction.
That we will hear separately.
That will appear tomorrow, my lord.
No, not tomorrow. First, we will sign this order.
Sorry to hold your lordship even during the recess last time.
My lord, I have filed my affidavit in reply, may be kept in record. In the section.
It's always pleasure to hear advocates.
I'm sorry, my lord.
Pleasure to hear all of you.
It's always similar. My lord.
Affidavit in
equally privileged for us.
I have filed.
Thank you, sir.
My lord, is it your lordship desire to keep the matter any post?
You will give a date. Give some date.
Deeply honored. Great.
2:30.